All right, just want to let you know, this is live from the courtroom. We are on lunch break. Let me see if we can get the chat working here. I'm going to take a brief lunch. I'll be back. Oops, let's turn that one off. That's a little confusing. This is going to be a long lunch, so we need a little... How about this? Let's put that on right here. There we go. Oh, Jules is calling in. Let's take Jules' call.
Call from
Jules. Yeah, because
Hey,
this way I
Jules.
could lock that up. Hi. Okay, listen, I got Susan's contact information for you.
Okay.
So whenever you're ready, just reach out. Make sure you let her know that you got it from me.
Okay.
And defense is going to rest today. There's a very good possibility, depending on how quickly they're moving, that rebuttal may even start today.
Right.
Rebuttal will be done tomorrow, and depending how long Mr. J takes, closings may also start tomorrow and get into the jury's hands. I was going to leave tomorrow to go home, and now I have to break the news to my kid that I think I need to stay.
Jules, you're doing an amazing job. You do what you need to do for you first. Thank you so much.
I know.
That is.
You're welcome. But I have to tell you what Susan said.
Yeah.
Okay. She's watching very, very closely. She watched Sarah's testimony yesterday, and in her opinion, she agrees with me. She felt that Sarah did an excellent job on the stand. But we're going to lunch. Her, myself, and Joel from Surviving the Survivor. I'm going to get more info from her.
Awesome.
But yes, she's open. She's open for, and she also recommended me for a job.
Hey, that's awesome.
As a professional court watcher.
That is cool.
Like, can you imagine? Anyway, that's all I got for you. But I just want to let you know that this is gonna. It looks like it'll be a wrap by Friday.
Wow, that is awesome. We've made up a lot of lost time, especially considering we had a week delay because of the hurricane. Great. I'd say I give credit to the judge on that one. He's really done a good job in this case.
That's what Susan said as well. She said you've got to give credit to the judge, and I said I like him, and she says he's moving things along, and the best thing is that each and every time he always says to Sarah, "Are you satisfied with these decisions? Do you agree with these decisions?" So this way she can never come back and say, she didn't have
ineffective counsel or something like that. No,
right.
She's all along. She's said this was my decision. I'm on board with this. So there's no recourse on that front. There might be other ways that they can appeal, but not on that front.
Yeah, I think so, and I'm going to wait till after rebuttal to really make a decision. But for right now, I'm thinking that they may hang. I don't think they're going to, because Susan noticed that juror number 13 and her side partner were doing a lot of bonding together up there. And she said, if they're part of the actual, she goes, "Do you know?" I said, "No, they did it so quickly that I'm not sure." So she said she may have
she's definitely a deliberative. I'm not sure if the person next to her is.
Okay, well, Susan thinks that she can have quite an effect on the jury.
Yeah. And then then it's not one holdout. It's easier to have holdouts if you've got more than one.
Yeah. So I think, though, a hung jury, if they go in with the lesser included of manslaughter, they might just find her guilty of manslaughter. I don't think that they're going to get first. Do you think they're going to get second degree?
I think if they go guilty, they're going all the way. I think so.
Okay.
That's
okay.
I'll put that out there.
Okay. All right,
here's
that's
why.
all I got
Here's
for
why.
you.
She's confessed to malice. Okay. And malice is not an element of second degree. So I think if they go guilty, they'll give her the full charge.
Well, let me ask you this. What did you think about the video, the actual video of him smashing the TV?
Mixed thoughts. First of all, yes, it shows, I mean, putting the bat in his hand, showing that he's willing to do violence to something that most people would not do. That's beneficial to Sarah, but the context was missing. You're going to help me carry this crap out. It was already broken when he said that. Okay. We assume that he broke it the first time. We don't know anything. She wasn't crying in the background. She was just filming it like she was making a TikTok.
Mm-hmm.
So I just don't know if you can count that as a plus or a minus on her side.
Right. But I don't know. The jurors were paying very close attention to that video. Very close attention, taking notes.
I will say that I listened to George's voice, and we don't have much to compare his voice to.
Right.
But the way he was repeating himself, I thought maybe it might be a sign of intoxication.
Me too.
There were long pauses where he was like thinking. Maybe it was like a little buffer moment that might show intoxication as well. So that could have been helpful that way. But
yeah.
But it needed more context, and we end up relying on Sarah Boone's story, which she might be discredited on, additionally as we go through more rebuttal. But we have to trust her, and we know that she's lied other times. We just don't know which one we need to believe. Do we believe that this is what actually happened around that because she was the only other person there?
And also, I know a lot of people were saying that they felt that a picture of her with the black eye was doctored and fake and this, that, and the other thing. Well, obviously they had the deputy on the stand that verified she did have black eye. That was when they both were arrested.
The second deputy indicated that was an old injury.
Yeah,
because it had already filled in, the bruise had already filled in and colored and gone, the deep purple color. So he's saying that didn't happen just now in this altercation.
No, but that was the incident though where they were both arrested. He arrested both of them.
Yeah, it's crazy.
Very toxic. But in any case, I'll let you go. See you at 1.
Enjoy lunch. Tell
do.
Susan thank you. I'll reach out to her. All right.
I will. All right. Bye-bye.
All right. So we had to take that call really quickly from Jules. We are still on break. I'm trying to run a timer on the screen that might show you. Let's see if this works. That might show you that we're live. I just we're about an hour and 15 minutes away from restarting. Let me set this up a little better. Okay, let's turn camera 2 off. Camera 1, make that camera 6, turn that one on, and we'll crop this one down. This is just my iPad timer, guys. It's not anything fancy. There we go. You can see that we're live. Does that work? We're going to be back. We're going to be back about roughly about that time. But we'll keep the stream up live. The audio is live from court. If there is, for some reason, a hot mic, or if the cameraman decides to show something during the break, you're going to see it. I'm going to grab some lunch, and I'll be back here shortly. Thanks, guys.
Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
Is the next search on February 28, 2020, 7:44 p.m. How, does the FBI find people? The people's misspelled P-E-O-O-P-L.
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
All right, welcome back to the Court of Public Opinion. I am the Recovery Addict. I'm hiding here. I'll be back in a second. There we go. Music is so loud. Music is so loud. I have a confession. I have no idea who won the internet here on our break. We are at break. We are going to be coming back to court in just a few minutes as they wrap up their long lunch. Oh, she found out. She found out all right. Where we are right now, I'll show you live from court. Nothing's happening. We all won it. Everybody won. Oh, Zimmy is a winner? Zimmy was the winner. Let's see. Zimmy. We'll let the music die out here just for a second. Zimmy, my friend. Thank you for your exuberance, being first in chat. Clearly, you're excited to be on the internet today, and as punishment for that excitement, we're going to sentence you to internet ownership. That means everything IP-related worldwide is your responsibility to fix. What that means for you is you'll probably get more than a few. You'll get a lot of phone calls, and it'll be everything from resetting stove, microwave clocks to connecting thermostats, IP resolution, conflict stuff. You'll get the hang of it. If you don't know anything about it now, you'll learn on the job. That's pretty much how internet ownership goes. It's on the job training. But your phone's probably already starting to ring because I have forwarded all the calls to you now. So if you could just go ahead and take care of that we would appreciate it. In your spare time, you might want to head over to the shopping page on our YouTube channel and download your very own certificate of internet ownership. It's sort of like a rap sheet in a way. It is on your permanent record. You can download that form. It's fill in the blank. You put your name on there. It's already pre-signed by myself and my boss, Mrs. R.A. And it's suitable for framing if you want to hang it up on the wall, or you can use it as a cover sheet for your
Call from
resume.
Pam Jams.
Pam Jams, welcome.
Hi.
How are you doing?
I'm good. This is the first time I'm calling in, but I've been here since Daryl Brooks here in Waukesha.
I was going to say, well, your name's been in chat since you're an OG. You're an OG.
Yeah, and I'm a paralegal, so I've been busy. So I'm in and
happy
out.
Paralegals Day.
Yeah, thanks.
Yes. I'm glad I got to wish somebody that.
About to catch a whooping.
Yeah, thank you so much for all you do. And so my question, I have a couple questions.
Mm-hmm.
Do you know when he died? Do they have a...
They don't know exactly.
Date of...
It's going to be... It's either the night of... It's the 22nd or 23rd or the 23rd and 24th. I forget what it was. But it was either that night or early that morning. But they don't have a firm date.
Yeah. So I've been in and out with this, but did he? Was there blood on their pillowcases in the bedroom?
Not that I heard.
Okay.
Nothing like that upstairs.
No blood on pillowcases.
No blood.
Because I'm thinking. So I'm actually a work comp paralegal now. I'm kind of semi-retired, and we represent the injured worker. But prior to that, I was on the very, very dark side as a criminal defense paralegal. So I saw a lot. It was like, yikes. But my thing is, I don't believe the hide and seek. I think something happened upstairs. I think the suitcase was upstairs.
Hang
the
on, hang
bat
on.
was upstairs.
You don't believe
Sure.
that George just said, tag you're it, and that meant they were going to play hide and seek, two people in
No.
a 600 square foot apartment?
No.
What about that story don't you buy?
So, yeah. And so I think something happened upstairs. She bashed him with the bat, stuffed him in the suitcase, threw him down the stairs, and then did the videos, and then maybe bashed him some more or whatever. But I think he died sooner than later.
Yeah.
You know, and I don't think there was any gurgling when she woke up at noon the next day.
I think,
and just from seeing dead people, I don't think he was blue. I'm sure he was white by then because all the blood would pool to like the heaviest portion of where his body finally ended up, you know, like his hips or whatever.
that's what we don't know. We don't know what position she left him in. Like, we know where the video ended, but we don't know. He may have been face down. And had a pooling on the face. And as far as I know this is a little rough for right after lunch to dive into this, but as far as the gurgling on CPR,
I just had vegetable soup, and I'm not gonna.
I had the.
I have a tough stomach now.
I had the unpleasant experience to also find someone who had passed a while before, and we didn't know they had passed. Hopefully, I'm not. There's somebody in chat who experienced this with me, so hopefully I'm not saying too much. But
my mom,
we tried to roll
it
them
happened
over.
so quickly.
There was gurgling just because gases and fluids in the body settle.
Oh, yes, correct.
And even long after death, that can occur.
Yes.
So.
Yeah.
But yeah, hide and seek, it's not how I remember the game going. It's not.
Yeah.
That's not it.
So, yeah, and I love Dr. G. I watched, on break, I watched his analysis, and there's quite a stark contrast between her, you know, right outside the house, right when the police came, versus when she's in interrogation room, versus when she's on the stand.
Yeah.
You know, so... Yeah, and a lot of time passes, and she's got a lot of friends in the crib, her new crib. So
one very good one, apparently. He was in court watching.
Yeah.
So I'm glad she has some support. I mean, court is not fun for anybody, and as we always say, innocent unless proven guilty. We need. Some of us say we've seen enough already in there, you know, to vote, but. Somebody's right in front of the camera.
Yeah, and not buying the whole thing about, you know, she was scared to let him out of the suitcase. You know, you can call 911. Please call 911. Get out, you know, take everything and just leave. It's just not worth it.
Yeah,
and it's so sad, you know, for her son who's like, what, only 14 now?
I thought he was 14
14?
then.
Oh,
Is he 14 now?
I don't know.
I don't remember. It is terrible. I mean, he's 14 now. Okay, that's really bad. Oh my goodness, 14 on the 28th. He's gonna have a birthday right about the time the verdict comes in.
Yeah.
Wow.
Well, thank you so much. I just wanted to call in. Thanks for taking my call, and good luck with everything.
Well, Pam
and
Debs,
y'all
thank you.
Be safe out there.
Nice
You're welcome.
You. Have yourself a great paralegal day.
Okay, thank you.
Right, bye-bye.
Bye.
I love it. I love putting a voice to the names we hear on chat there. Let's see. So during the break, you might have seen I was poking around on my desk a little bit. Rerouted some cables, rebooted a few things. We now have the replay machine back up and working, which was something I did not have yesterday afternoon and this morning. So now we will be able to go back and replay things as they happen in slow motion or frame by frame as needed. As sometimes things happen really quick in court. Or quickly, I think is the correct way to say that. Just Breathe says, hugs to my favorite online family. Thank you, Just Breathe. Virtual hugs all around. Thank you. Congratulations on 16 months. Wouldn't be the same without you here. Appreciate that. Jerry isn't buying it. Georgian's suitcase speaks louder than her mess. I thought you took naps during lunch. Krista. I don't remember I don't think I've ever taken a nap during lunch. I might be wrong. I can tell you this. If I did take a nap during lunch, I would have come back and told you that I did. I would probably have come back late and told you that I did. I don't sleep very much during the day except for Sunday afternoons. Do you see how out of breath he was batting? I did, Judy. That seemed curious to me because we don't have any explanation as to why he is out of breath. I think I'm about to catch a whooping. Thank you, Lisa, for that soundbite. Missed some parts. Did her ex testify? I believe Brian testified on Friday. Correct me if I'm wrong. I was driving to South Carolina with chainsaws and fuel in the back of my car. I was not able to watch all of that, and we had some technical issues on our transmitter end, so I do apologize for Friday's stream. We got those sorted out now. Thank you muchly to LiveU and Trail TV Live. LiveU was supposed to call me and talk to me about the problem and how they're going to fix it. Instead, they just sent me an email saying, oops, our bad, and they gave me a month credit. So we pay I don't know, $300, $400 a month for the connection, just for that LiveU. And they gave me a month's credit, which is nice because, when it doesn't work, the frustrating part is I've had that problem every time we activate that LiveU to go on remote somewhere. Every single time.
Somebody just sent me a video of
All right. Yes, I take naps during the stream, not during the breaks. You guys have figured me out. What's the plan on catching up with Melody's trial? Lindsay, we're here for the duration until the verdict on this. Possibly, if Verdict Watch goes a long time, we might do some court catch up there.
May be upon us.
Hang on. Let's see who's calling.
Call from
the Emmy music video.
I think this is Mathis. Mathis, is this you? Hello?
Yes.
Hey.
Yes, can you hear me?
I can hear you now.
Very good. I'm also very happy you recognized me from that announcement.
I see your caller ID. It tells me your number.
Very good. Okay. So I was going to ask you if you have made any progress with the short you had announced.
The short... You know how Sarah Boone made a shirt? Well, we made a shirt out of Sarah Boone. Let me correct this. Greeners made a shirt out of Sarah Boone's advertisement saying seek an attorney. I think I'm seeking someone to help me with short videos because I'm terrible. I'm terrible at... There's Greeners. I made a shirt. It was Greener's shirt. I have not made it yet. I have the sound. I need to do it.
Okay.
Yeah.
I've been working on more of those AI-generated songs in the hopes that I would eventually be able to do them together. And I think I'm more or less through chapter 1 out of 7.
Are you focusing on Maya? On the Maya?
Yeah, I'm still trying to do the Maya up here. It's really difficult to get the AI to consistently spit out something that's usable.
Right. It takes some work.
I think that form of speaking.
Yeah, we'll. I still want to do that. You've sent me some great stuff that I have not played, and some great stuff that we have played, and I'd like to go there. That is on my to-do list. I just right now, with this case, with our team down in Florida that's working down there, and the tech side that we have to work out every day, we have been. I don't know. Amazon has been our friend. With help from some generous people here in chat as well, backup batteries, hundreds of dollars worth of cabling, all sorts of stuff. We're coordinating all sorts of things to keep the feed, what we get from court, working and as best we possibly can have it. I just have not focused on the short at all.
Yeah, I hope you'll get some breathing time to get that done.
I do as well. I owe it to you because you've done the hard work on the front end. So Mathis, and the audience is waiting. They're clamoring for the next song. So, do you have a SoundCloud or something we can listen to? Do you publish them somewhere?
Not yet. I thought about maybe making a YouTube channel where I then upload something that's big enough, like a reasonably sized legal document. The problem is when you're trying to use the AI, there's a limit on how much you can do, and a lot of the outputs aren't going to be like appropriate. And then there are some that are going to land like super spot on, and
it's like a 1 in 10 type or maybe 1 in 20 that just nails it. Some of them are good, but 1 in 20 probably just nails it.
Yeah,
I will keep you updated. I'll commit to that. We're gonna get there. We're gonna get there, and we'll get that video up. I think there's an option to export them with video, which is basically just the thumbnail image and the text. I think that's the preferred method for me, because it's easier to follow along with the words, especially if some of them are a little rapid, if you can see it on screen. So that helps you to hear what understand what you're hearing. But good.
Yeah, I see.
Make a YouTube channel, and we're gonna plug it, and we're gonna get you. We're gonna get you.
I have made the YouTube channel. It's just going to take forever until I have something like good to upload there.
No.
Because I want to do like at least like a chapter of a brief, and I feel that I have to do at least also probably the initial defense brief, because I want to give like the filings by both sides. And the problem is really just you can make like 10 songs with a free account, and then you can use a Suno clone that basically logs into Suno for you, I think. And then you can get like, I don't know, if you're doing some trickery, you can get
a few more,
like 200 songs a day, and that's
we might have to spring for the pro version for you, so you can get like the extra 50 songs a month or something that they allow you to get.
I think it's 500 songs a month if you get the like the $100 a year one, and I'm thinking I want to try that. It also has a really good feature that I wish I would have had understood earlier, where you can extend stuff.
Yes.
And I think what I need to do is just pick one song that really works, and then try to extend it and manipulate it that way. But
it's a little finicky on the extension thing when I was using it. It's tough. We used it on Big Dill. Mathis, let's see. Hang on. I'm going to take you off the air for just a minute. I need to ask you something. Is that all right? But I need this to be off the air because it's personal. Just 1 second. I just didn't want him to be on the spot. We're talking about a little bit of collaboration with some of what he does with the music, and I didn't want him to be on the spot in front of all of you and feel pressure to answer a certain way. Krista, are you using the new iPhone 16 Pro Max yet? Yes, I got it. This is the 16 Pro Max. It feels like a tablet. Honestly, it feels like a tablet. And I upgraded from the 12. Okay, this is the 16 Pro Max. That one I just showed you is the 12 Pro. It feels like a tablet in my hands. I'm still transferring over and activating all the logins and things in the apps. Once I'm done, I'm gonna turn in the 12 Pro, I think. Do I love it? Not yet. I don't love it yet because I've had problems with it just losing Wi-Fi every couple minutes, like completely just dropping out, which has not been great. Do you give the old one to the wife? Thought about it, but I get $1,000 credit according to AT&T if I turn the 12 Pro in. I'm pretty sure that was an advertising gimmick, and it's not. They're not going to give me the $1,000, but that's why I got this phone, is because of the credit. The 12 Pro, if Mrs. RA got it, it needs a new battery desperately. Oh, and I was talking to Mrs. RA about the recipe that we made last night that I told you about, the Italian sausage, spinach, and it's like a cream-based gravy. Ooh, the secret sauce was that the hot pepper flakes that I told you about. She used the smoky hot pepper flakes, and they were, oh my goodness. Sort of like Alfredo, yeah. It's like an Alfredo base. Anyway, all right, we're about to come back to court. Welcome one and all. I think we have about 10 minutes before the judge should be back, but he did say that he asked the jury to be back at 12:50, right? So we'll see. I'm saying my phone is not. She's worth more than my phone is. She would be worth another 16 Pro Max. I wouldn't want to give her a broken phone. Mine's not broken; it just doesn't work. Flat iron pepper flakes. Oh my goodness! Let me show you just one second, because I tasted this and it changed my world yesterday. I ate way too much of this. The particular ones that just absolutely made the seasoning. Here it is. It's taking forever. Just one second. All right. I just put a link in chat. This link is to the flat iron pepper flakes. It's Amazon. It is an affiliate link. If you buy it after clicking on the link, I think I get like 3 cents. I have to tell you that every time. But that smoky flavor added to the Italian sausage, oh my goodness. It was so good. And my wife and I said, hey, I'm going to go have the leftovers. And she's like, don't eat it all without me. And we went out there. We split the leftovers and ate all of them this afternoon. It was so yummy. So I have to say, Flat Iron, that company, if you've ever had like just generic red pepper flakes, like from a restaurant or something, there's no flavor. There's no flavor profile at all. It's just like a little bit of heat, and that's it. Flat Iron just it tells you what pepper can taste like without also burning your mouth off. This isn't something that Ian Runkle is going to be like, oh yeah, that's hot. No, it's not. It's not. But yeah, it's really good. Who the sneezer in court is. Found out who the sneezer in court is. March 13. I always thought that the people were sneezing in court just so they could be blessed by the judge. I think people are intentionally sneezing just to be the judge blessed me. I have his blessing. I think I'd be like trying to pluck a nose hair or something, trying to get a sneeze worked up just to get the judge's blessing. Italian sausage already has some good seasoning, but this the flat iron pepper, whew, it's a smoky flavor, so it works really well with sausage. It's pushing up the cost of the transcript. All these bless yous. He's got like a page of bless yous. Right now we're on. Let's see. We're on 20 on the bless you counter. Oh no, did I mess up? How did I mess that up? Oh, let's turn 1 off and 2 on. Boom, there we go. There's 20, and we'll update this link to show our bless you counter as well. Right there. 20 bless yous. Patricia, I love this shirt. Absolutely love it. I try to wear it at least once a week. I have multiple blues. Like I think I have 4 blues, 2 short sleeve, 2 long sleeve, all the same color. Also my favorite. I just love these shirts. They're so cool. I just subscribed to the Pepper Flakes. Forget ordering one as a sample. Just ship me a new package every month. That is awesome. So 20 bless yous. We were up to, I think, 60 or so on the not intentional references. Brian said it in his police interview. You guys told me how many I missed on Friday while I was driving to South Carolina. What's yet to come in 6 minutes? A quick recap of where we are. Defense is nearly done with their case. We have an expert witness who is coming in, probably one who did sit down and evaluate Sarah Boone. She's going to be the I think it's a she. Might be. Is it? Which one is the guy that? Am I thinking the right case? Is this the guy that had the body parts that faced some charges for having body parts in a storage unit? Do you guys know what I'm talking about there? I might be mixing my cases up, but I thought I thought that occurred here. Yeah, everyone's like, what? Yes, there was an expert witness in a case that had some charges because he was like might be a different case. Hang on, I have to post this because this is just funny. Grace, thank you for the father-in-law dad joke. What is a priest who became a lawyer? A father-in-law. Did you say the flakes not spicy? They have a variety. I showed you the ones that we used in our recipe. Sorry, I'm talking about 3 different things at once. If you want the ones that are not spicy, you get the green lid, and I'll send you a link that shows you all 3 bottles. The green lid is the regular pepper flakes with just great flavor. The black lid is smoky. The red lid is fire. So there's the link to that shows the 3 bottles. That's them. You season those on a baked potato, and it brings it to life. It's amazing. It's amazing. All right. Somebody tell me what's the name of the expert witness who faced some charges for the charges basically made it sound like he had body parts in a storage unit. And in reality, it was a medical examiner who had like a skin sample or something. It was not like heads in jars type thing. Bella says, I have no body parts in my storage unit. Sarah Boone says, I think the state tampered with a suitcase to make it more difficult to zip. Just saying. And blame the gloves. Blame the gloves as well. I didn't have these evidence gloves on the first time as well. All right, judge is back. Not sure if we're going to get audio right away or if we're waiting for Sarah Boone. Law students at his side, dressed sharp. Looks like Sarah Boone is present with her attorneys, consulting with them. I don't think it's an accident the attorneys keep their files in a pink folder. Judge, your turn. You're up.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. Let me get appearances for the state.
Steve Castro on behalf of the state. William Jacob State.
Defense.
James Owens for Sarah Boone. Tony Henderson, Sarah Boone. Kevin Beck on behalf of Sarah Boone.
All right. Ms. Boone is seated at counsel's table wearing the same dark gray suit and maroon blouse from this morning. She is in custody. However, there are no restraints as she will be standing as with the rest of us when our jury enters and exits. It's 12:57. State, anything we need to address?
No, sir.
Defense.
Judge, I've got something. Can we approach the bench?
Yes.
Hang on, the jury's not here. Can we just do this one in public? Can we duke it out from the tables? We're expecting expert witness testimony on the part of the defense, and this will be probably very specifically talking about Sarah Boone and why the battered spouse defense is appropriate here, what she's experienced, why that is the case. This is the big money. This is the big money expert, the sell your soul expert. No, did I say that out loud? Some experts seem to pick up cases that no one else will take, and they generally are at the very end of their careers. I'm just calling it as I see it. Pentouffle, thanks to you. Now I have to mail Pickles to Bestie. Spicy maple bourbon pickles. Oh my. Okay. Now, since I've told you about the pepper flakes, if you just found the channel, spicy maple bourbon pickles for sale at Walmart and Foodland. They're store brands. I think it's Sam's Choice at Walmart and the Foodland brand at Foodland. They're like, I think they're about $4 a jar. They're top shelf pickles, and by that they're usually on the top shelf. You have to hunt for them. But wow, oh wow, life changing. They sell them in the single serving jar, the big jar. They're so good. It is a sandwich pickle, but it's got some heat. Really, really good. Having some with my lunch right now, says Shaky Ground. Good. I'll see if I can talk Mrs. R.A. to getting some at the store today. Kells Bells. Speaking of big money, I ordered 3 bottles of Pepper Flakes. Spend that 6 cents wherever you want. Thank you, Kells Bells. I do appreciate that. Michael Birkeland was the medical examiner who was charged. Okay, Robin, what case was he in? Because he's recently he's been involved in a case. I thought it was out of Florida. It's not this case, is it? Wicked Pickles or Wickles Pickles? I have had them. They're good, but not spicy maple bourbon good. I don't know how to make a wish list and share it with you, Judy. Amazon, this is funny because I literally have been an Amazon seller for nearly 20 years. Like I have an Amazon third-party seller account. For a while, that was my main source of income. I don't know how to make an Amazon wish list and share it with you. Go to Mod Chat for a link. Okay, thank you. My mods are helping me out with Amazon. Katia, we need to figure out how we can text each other because I need to work in that area and I can't text you from my phone because of the long distance. Amber, as soon as they come back.
Scott?
Yes?
It'll be quick. One, you have already shared an Amazon wish list, like when we got your browse. So you can technically reshare that if you wanted to. And I've got Katya on Discord as well, and she and I are chatting. So I will end up calling you after stream.
Sounds good. Amber, this is what we keep you around for. Thank you very much. Appreciate
Not
you.
a problem. But yes, you already have a...
I already have one, guys. I'm scared to see what's on it.
Lots of eyebrow stuff at the moment.
Oh, when we got the eyebrows for... We're talking the eyebrows for Brandy's verdict watch. These things. Yes.
Yeah, those things. The massive caterpillars.
They're pretty good. I was hoping for the monobrow, but they came
I
as
mean,
two
I
separates.
can make that happen.
All right. We might have to do that. Thank you, Amber. Appreciate it.
You're welcome. Bye, everybody.
That is Amber. Calypson's Vixen in chat, one of our great mods. I just want a decent microphone to try and talk to myself. Judy, I love this mic. That's why I use it. Okay, if I didn't like it, I wouldn't use it. This mic, this cover is about $7, and I love it because you can take it off and wash it, and your mic will, you know, a lot of people talking and spitting on your mic after a week is going to smell bad. So you take these off, you wash them, and it keeps it cool. This mic is called a Rode Pod mic. And do you hear that sweet spot? Ooh, it's got a sweet spot. You can get this. My version is $99, and it's XLR only, meaning it takes the big 3-plug professional connection. If you pay an extra $100, I know it's a lot of money, you can get it so it has both the XLR or USB. So you can plug it straight into a computer that way. And it's the same beautiful sound, same shape. It just has the extra plug on the back. Big fan of that. And this sounds, to me, my ears cannot hear the difference between this mic and SMB7, which is just that's what like Joe Rogan uses on his podcast. This is a good sounding mic. Great pop filter. I'll have to get a link for that for you as well. How often do you really wash it? I rotate them. Like I have one right now on the dryer because I have 3 of these mics. So I've got like 2 here, and I've got one on a standby microphone, like a whole spare mic. And so I rotate them about once a week. Just use it like a sponge with like dishwashing soap. And then the fun thing is you can like put it on a hairdryer with the heat turned off, and it just like dries the thing out. It dries it from the inside out.
All right, thank you all very much. Mr. Owens, if you can see to calling Dr. Harper at this time to advise her to be here at 1:30 for her testimony.
Yes, sir.
We have a half-hour delay for Dr. Harper.
Just in 1 second, sir. Thank you. I'm waiting for Mr. Owens to return.
Judge, that did not sound good.
Thank you, sir.
Not sure what that was about with the bailiff. Usually the bailiff doesn't talk to the judge during court.
Judge, may we approach him?
Without Mr. Owens?
Yes, sir.
Sure.
May we approach without Mr. Owens? Mr. Owens just came in the back door. The judge says, "Hey, Mr. Owens, get up here." Mr. Owens says, "Hey, Mr. Beck, you get up here as well." It's going to be a whole big party up there at the bench. My friend adds the pickles to a Coke Zero on ice. Pickles and Coke? It was going to be a conversation about Mr. Owens, but now he's walked into the room, so they have to think of something else to say to the judge right now. Let's see. Amber, I think what I want to do, I get a lot of messages about people who want to start YouTube and want to know what equipment I use and what They want
All right, as we've discussed,
put those items on.
we are not going to be having the charging conference regarding the jury instructions at this time. That will be conducted tomorrow. I have requested the defense to provide any instructions that they are seeking to be provided to the court and to the state in Word format tomorrow, including but not limited to 3.6F or 3.6G and any portions thereof that the defense is seeking to utilize for the purposes of jury instructions. The court throughout the trial has been redlining the jury instructions that were provided initially by the state. At the end of the evidence and testimony presentation this afternoon, the court will email those to all parties. Once Mr. Owens comes back in from advising witnesses of when to be here, we will bring in our jury and proceed with the evidence presentation this afternoon. State, anything else we need to address?
No.
Defense, anything else we need to address?
No, you are.
All right, very good. As soon as Mr. Owens enters, we'll bring in our jury. The deputies will assist Ms. Walker in the wheelchair into the jury box.
Okay, I had no idea Miss Walker was in a wheelchair. I'm just trying to point out, and there's nothing wrong with being in a wheelchair. It sounds like she is elderly.
I've called her 3 times. I did text her. I don't know if she's in the process of switching rooms.
No worries. We'll cross that bridge at 1:30 if she's not here, sir. Okay. All right, let's go ahead and stand and bring in our jury.
Trying to find their expert witness, Miss Walker. Does give us throwbacks to Letitia's trial. Mr. Beck appears to be praying, as does co-counsel.
All rise, jury's in.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
All right, everyone can be seated. Thank you. Members of the jury, again, welcome back. I hope you enjoyed your lunch. I see juror number 5th from the right to left, second row. His hand's already out. He knows what's coming. If you can, just raise those hands. Confirm you complied to the court's instructions. Record reflect all hands have been raised. All right, members of the jury, the defense is going to continue with their evidence and testimony presentation this afternoon. Thank you. Mr. Owens, you may call your next witness, sir.
Your Honor, the defense calls Mr. Pearl Walker.
Okay.
I thought they said they couldn't find her. Looks like she's here. They're 2 different people. There's a wheelchair. Bailiffs are going to help the chair into the witness box, I believe. You can get the chair out of there so she can. Or she's going to try to walk up.
I approach the witness, Your Honor, just in case.
I think the deputy's got it, sir.
Got it, okay.
They have a special wheelchair entrance to the witness box. That's convenient. Hopefully the chair's been moved out of the way.
Ms. Walker? Ms. Walker? Can you raise your right hand to be sworn, please? Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
Ma'am, good afternoon. Could you state and spell your name for the record for us?
What did you say?
Can you state and spell your name for the record for
Walker.
us?
Pearl Walker, Walker.
Thank you very much, ma'am. Mr. Beck, you may proceed.
Good afternoon, Ms. Walker. Ms. Walker, do you know the defendant, Sarah Boone?
Yes.
Okay. How do you know her, ma'am? How do you know Ms. Boone? If you can't hear me, just ask me to repeat myself. And I'll
Okay.
do so.
Okay.
How do you know Ms. Boone?
She lived in the same apartment building that I lived in.
And can you tell us how long the two of you shared the same apartment complex, apartment buildings?
About 4 years.
And how is it that you became familiar with Ms. Boone?
My husband and I was sitting out on the porch, and we see her coming with her 2 dogs.
And what happened then?
Then I would call her over with, with her dogs.
And what do you mean by call her over?
When I see her walking with a dog, and I see her and I look at her, and I said, "Hey, Sarah, how you doing?" And that's it.
And would she generally respond to you?
Yes.
And how? Look, I won't go there. Would you spend time with Ms. Boone?
Did I spend time?
Would you spend time speaking with Ms. Boone?
Yes.
How long would you speak with her?
About 15 or 20 minutes. That's all.
And was your husband sometimes involved in those conversations as well?
He'd just say hi.
So you and Ms. Boone were the 2 primary communicators?
Yes, sir.
Okay. In the time that you knew Ms. Boone, did you witness anything about her person or her body that gave you cause for concern?
Sometimes I would see it like she had been choked around her neck or her arm be hurt. Have a mark on her arm. And I just asked her.
And would she describe how that happened?
She'd just say, I had a...
Hang on. The objection is sustained.
That was hearsay objection.
When you would ask her that, how did she appear to you to respond emotionally to your questions about her injuries?
She'd just say, one of them days or something.
Objection sustained.
Just for the record, instead of telling us what she would say, would she demonstrate any emotion on her face?
Well, I would see the emotion that she was upset about something.
And did you ask about her obvious upset persona? Her upset, the fact that she was upset? Would you ask her about that?
Yeah. Well,
okay, you have to just limit your answer to the question. Would you ask her about that issue, about why she was upset?
Yeah.
Okay. And I'm sorry, I just can't go beyond that. Thank you. Now, how frequently would that occur?
I would say on the weekends when I see her.
Was that primarily when you saw her on the weekends?
Mostly I would see her walking through, going to her place, and I'm sitting on the porch and I see her then.
Now, strike that. While you were there in that apartment complex, and excuse me for getting ahead of myself, do you still live in that apartment complex?
No.
How long have you been gone from that apartment complex? If you don't know, that's fine.
Oh, it's been a while.
Thank you, ma'am. During the occasions that you had to interact with Ms. Boone, how did she treat you?
Objection.
She was a nice lady.
Overruled.
Nice to me.
Did she ever act uppity?
Objection. Relevance.
Overruled.
Did she ever treat you in an uppity manner?
What you mean, sir?
Did she ever look down on you as a person?
Oh, no.
Did she ever treat you with disrespect?
No.
I'm going to object. This is character evidence.
Sustained.
May I approach on this, Your Honor?
Yes.
Let me just call out Mr. Beck quickly. This is not a witness you should be unprepared to question. It's not extremely technical. It's not extremely detailed. It is a witness who has simple, direct testimony, and you should not struggle to ask her direct questions. That this is poor planning. I realized they were going to do this over Zoom. They would still have to ask the questions if they had allowed this over Zoom. This is dragging her in here and then throwing a 4-part question where you start 3 others before you ask the final one, and then interrupt her before she has a chance to finish. That is not looking good for defense. She has some good things to testify to. It looks like Sarah Boone is smiling ear to ear to the witness, and I'm observing that from in back. That appears to me that she is smiling at the witness, trying to possibly encourage good responses. The state is right in objecting to character evidence. That's not allowed in. I'm wondering why the state or the defense did not call the 2 ex-wives of George. The state should call them if there was no history of abuse. And defense should call them if there was. I just think they have nothing to lose. Okay, granted they might have a dog in the fight that they don't like him, so that might go against the weight of their testimony or the truthfulness. But this is his 3rd relationship that was very close to marriage. I believe they were engaged according to Sarah Boone's testimony. He had 2 prior relationships. If he was violent in those relationships, wouldn't that be a huge win to bring that in or be able to get that in court? Of course, that might be the character evidence that is being excluded. Diet Coke on the table today has replaced the Red Bull for Mr. Owens. Cheryl, we're going to be going back to the Harris trial once this one's over. We're going to speed trial and catch up. We may skip. I'll see what I can do. We may skip the testimony that happened on last Friday, because there were 25 jail phone calls between the defendant and
objection sustained
boyfriend. Were really hard to hear. I'm not sure if I can fix them.
I'm sorry, I'm back, Mrs. Walker. In the time that you and Ms. Boone lived together, on occasion, did you see law enforcement arrive at the apartment complex?
A couple of times.
And did you ever get involved in any of their investigation?
No.
Were you ever approached by law enforcement and asked for information, evidence, insight into what might be going on?
No, sir.
Now, in all candor, Were there occasions when you believed that Sarah Boone may have been under the influence of alcohol?
No, I can't say.
Did you also observe George Torres during the time that you lived there in the apartment complex?
I didn't see him very much. If we're sitting on the porch, that's the only time I see him.
Did you know Mr. Torres very well?
No.
Was there an incident when you saw Ms. Boone with a black eye?
Yes.
Did you witness a pattern between Ms. Boone and Mr. Torres wherein you observed signs of abuse?
Objection. Nomination.
Sustained.
You testified that you saw Ms. Boone on occasion with bruises, other injuries, and a black eye. Is that correct? Is that accurate?
Yeah.
And was there any pattern to what you observed in regards to those injuries and bruises that you observed on Ms. Boone?
One time I seen with a black eye and like she had been choked one time.
Okay. Did Ms. Boone complain to you about those marks?
Yes.
Thank you, Your Honor. Nothing further.
Any cross-examination?
Hi, Ms. Walker.
Hello.
Is it fair to say you're not sure when exactly you saw any of those injuries on her, correct?
Say that again?
You're not exactly sure when you saw any of those injuries on her, correct?
Once she come past the apartment, I'll be sitting out there because we always sit out there.
Right, but we don't know if this is December or 2018 or anything like that.
I can't remember, sir.
Okay. And is it fair to say you have no idea how she got those marks? Is that fair?
Repeat that again?
Do you have any idea how she got those marks?
It's worded poorly.
On the weekends, I see him and her go in.
Okay. But you don't know who, if anybody, put those marks on her, right?
Well,
Just calls for yes or no.
I can tell when they must have had an argument or something. I hear the dogs barking.
Okay. And you're 5 doors down, right? Unit 8, Unit 3?
Yeah.
Okay. No other questions?
Any redirect examining?
No, Your Honor. Thank you.
Can this witness be released?
Yes, sir.
Thank you very much, ma'am. Ms. Walker, the deputies are going to come get you and take you out, okay?
You all done?
Yes, ma'am. Thank you so much.
It's like you dragged me down here for that? That's it? Nice lady. Nice lady. I'm guessing that's probably her first time in court. See if Sarah looks up as she comes down, makes eye contact. Looks like she does. There's a smile. Ms. Walker looks straight ahead. Now we're almost at 1:30. We're waiting for the next witness. We might have another break.
Defense, ready to call your next witness?
Could I have a moment?
Yes.
Mr. Owen says, "Can I have a moment?" Grabs his phone. That's not a good sign. He's been texting and calling this next witness without a response. Culperistic. Mr. Owens is telling the witness to break the traffic laws and he'll pay for the ticket. This is the last expert. We may rest after this. I don't know if they'll call anybody else. If they can't get a hold of the witness, I wonder if the judge is going to say, "Look, it's your job to get him here on time. If you're not able to proceed, you need to rest." That would be a massive loss. Massive loss for Sarah Boone. I imagine he would probably call a break for the day. Instead, dismiss the jury and call a break. Maybe work on jury instructions. They won't do closings today. They might start rebuttal. Should have a sneeze here during this lull. I'm detecting someone with a little tickle in the nose. Let's see if my spider sense is working.
Yes.
Can we approach? Erica, it must have been your coworker I was detecting. My spidey sense. Approach is not good. Approach means that the witness is still not here. And worse than not here is the last 3 or 4 times that Mr. Owens has tried to reach out to them, they have not responded to either to text or phone call. She flew in this morning. Why aren't we counting anything? We are. We're counting the bless you counter. We're up to 20. Anytime somebody sees us in court with the mics on, the judge says, "Bless you."
All right, members of the jury, witness is running a couple minutes late. I think they may be stuck in the security line downstairs. So we're just going to be in a short recess for them to join us this afternoon. Similar instruction that I've given you, please do not conduct any independent investigation or research regarding the person, places, things, or charge involved, and do not have any discussions amongst yourselves or anyone else, and we'll bring you back in as soon as that witness arrives. Thank you again for your patience.
All right.
See if the judge steps off here or if we do anything else. We might be able to do some business work that needs to be done in court anyway before the jury actually gets charged and receives the case. Possibly jury instructions.
Y'all can be seated. Thank you. We'll be off the record until Dr. Harper arrives.
Nope. Judge steps off. Wants to talk to his law students instead. Might be in the jury line. I've heard for those guys we have down in court who are attending there in person, the lines are terrible. First of all, driving in traffic is terrible in Orlando. We've heard that. It's just awful. And the lines to get into court is awful because, as you know, this is a big courthouse. We've been on floor 12 and floor 23, and you've got courthouses all over the place. So a lot of trials going on at the same time, a lot of juries being selected, all requiring people to show up at court.
AWOL.
AWOL, I saw your comment a minute ago, and maybe you're going to ask about that, but I think I have the answer for you. Do you remember what the comment was?
Statement of a party opponent?
Yes, that was the one. The reason why, and your question was, why can't they allow this witness to say what Sarah told her? The reason why they can't is because it's on direct. It's their own witness. The state could elicit that, but defense cannot.
You're right, because it would be hearsay, because it could be flattery. You're right.
Yeah. So
now I have. Oh, I'm sorry. Go ahead.
I was going to say the purpose for that is to require the defendant to testify if they want that information to come in. Otherwise, you could have the testimony of the defendant brought in without them ever taking the stand and being facing cross-examination.
Correct. I was thinking of this. I have a thought experiment for chat that I would like to do.
All right.
Or if they want to participate, but in order to do this thought experiment, chat has to suspend the belief of their good moral character of themselves. If they're good people for this thought experiment, you have to suspend that belief in order for you to take part in it.
You've intrigued me. I'm willing to use the poll option to gather results. So go ahead, ask your question.
I understand we read her letters, and I wish we didn't at a certain point, because now we're almost kind of mocking her, because not really. It's due to her crime. We give no sympathy, which I don't think she deserves any. But now, if that being said, if you did this crime, would you or would you not try your best to not go to jail? So yes, we in good moral standings don't think it's right to bring that witness down all the way down here at her age. But if you were on trial and that is an option, you would do that. You would 100% do that.
We're going to ask the poll. I've typed it in this way. I've said, if you did this crime, would you? I said, would you fight the charges? Because I always get typos. Would you fight the charges? And we're getting the anonymous
results. You get
results
what I'm saying? I don't.
Yeah.
I don't want to say. I'm not saying that she doesn't deserve jail or she's not guilty. It's just, this expert is a quack. This witness, why she do that to this person? And I think it's an emotional response due to the crime and the charges and the evidence that we know. But to say that her lawyers are wrong for doing what they're doing, I think is an emotional response, which I respect. But in a legal standing, you have the right to defend yourself, and I think you would do it. You would try.
I think you're getting right to the root of what a lot of defense attorneys, criminal defense attorneys, sort of like tout as their motto, that everyone deserves their day in court, that the state has to be held to their burden, that the state must prove. Something in my closet just made a lot of noise, and it's been locked for like 2 weeks. Okay,
a little mouse. Maybe it was a real one.
Thinking it's a possum or something. I don't want to open that.
Oh man, it was that loud.
Yeah, I'm nervous. It's like 4 feet away from me.
I see chat. Take the plea. Sure. Yes, that's an option. But if you still think that you can get away with it, you would bring an 80-something-year-old witness to the stand.
Does it mean you're trying to get away with it? Or do you
not get away?
Is there room for you to say, right? I'm going to plead not guilty in court to these charges, knowing full well that I'm guilty, because I believe that the state has to prove their case?
Yes, there are a lot of aspects to that. It can be make the state prove it. It can be I'm going to jail anyway. Might as well have a charade of it, right? It can be real issues where they're like, no, I'm 100% innocent. In her mind, she might think she's innocent. Or she can be like, I'm going to jail. We don't know. There's so many factors. But it all boils down to, would you, or whoever, I'm just saying chat, whoever, would you or would you not do everything in your power to fight it regardless? Mind you, you can't take into account that I would never do such a thing, because that's not fair for the experiment. Because none of us would, I would like to believe that none of us would put somebody in a suitcase, right? So that has to be,
I like
you know what I mean?
that as well. Hey, well,
yeah, I love to believe. I think I know that, but you get what I'm going at.
We've got nearly 600 votes on the poll, 575, 580 votes. I'm going to close it out now. I know it's early here; people are still voting, but the results are about like this. I've got 67% say yes, they'd fight it, and 33%.
64, you said?
67. So 2/3.
67. I think 33% of those people might be mistaken. There's like at least 10% of them that want to hit yes.
The margin of error is not that big. No.
Do they know it's anonymous?
Yeah, they do. But interesting idea. To try. It's always interesting to put yourself in somebody else's shoes, and it's especially difficult when those shoes are a very different size than the ones you wear. And I mean that not that
exactly
talking about feet, but the path somebody's walked in life, not necessarily, not just careers, financially, location, everything else. Just there's so much different that it's hard to just standing from your perspective, this is how I would see it. There's a lot there. There's a ton there.
Right, from entirety, the whole entirety, from the moment of birth until whatever incident we're judging somebody on. Sarah Boone, I don't know how old is she. Do you know how old she is?
She's my age. She was born in 1977.
Okay, she's 47.
She just had her birthday this month.
At one point, Sarah Boone was a baby, 6 months old, in a crib. At one point, this woman who did this heinous crime was a baby. Somewhere along the line,
but we're not trying her as a baby. I mean, we can't say
right. No.
We are back on the record. We're case number 2020 CF 2603, State of Florida versus Sarah Boone. State.
Hey, well,
Judge,
we're back.
We began trial.
We're back. Thanks
I
for the
had
call.
indicated that in the past, historically, in these types of cases, there are problems with cameras showing attorneys' laptops.
Happy birthday.
It's brought to my attention that is going on again. I'm asking the court to order whoever it is who has a camera, whether it be a phone or the court TV pool camera, that they not do that.
Okay. All right. Members of the gallery, good afternoon. And the TV crews as well. The information that's contained on both parties' laptops, be it the defense or the state, is protected by work product and attorney-client privilege. It's not something that's viewable, not something that should be disseminated, and not something that can be looked at unless there is a knowing, intelligent waiver, and that stuff's going to be put out in the public for consumption. So I'm going to ask you as best as possible not to view, take pictures of, or look at any of the laptops, be it the defense's laptops or the state's laptops, to avoid that. With regard to the camera, if we can, when zooming in on either the defense counsel's table or the state's counsel's table, if we can try to avoid their laptops, I would greatly appreciate you, sir. And the podium. Thank you.
It was not. It was not Court TV. I'm looking at this. Look at this. Sorry, keep this on. Look at this picture. You cannot see anything. The focus effect, the depth of field makes it impossible to see what's on a laptop. Just scrolling through this past, rewinding here. I'm not seeing any focus on laptops anywhere. Nowhere. Even right here, nothing. So if anything, that was done during by somebody like a pool media in the like a still photographer with a camera in court. And now, unfortunately, the cameraman who already has his position restricted by the court, where he can look restricted, can't show the jury, can't show the lawyers discussing anything, now also can't catch a laptop in the background. I think that was the state that filed that objection. This is coming from a courtroom that gives away all of its passwords. Yes. This camera operator has been good. He's held shots longer than I would have liked, but I know the restrictions he's working on, that the Ninth Circuit puts on him, and specifically the judge himself. And he's phenomenal. This is a professional court cameraman. This is not somebody who knows how to run a camera and he's like, sure, I can do it. This is somebody who knows exactly what they're doing. Court TV hired a good one here, and we appreciate it. Yes, this is a fun thing. You can build monitors. Back in the day, you could take the old calculators. You could take a calculator apart and take the polarized filter off the front of the calculator, and then you could only view the calculator screen if you were wearing polarized glasses, which are a lot of fun, or looking through a little polarized filter. Same sort of thing. What happens to a person that has subpoenaed for a jury trial and that person doesn't show up?
All right, we are
Contempt.
back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
Dave Castro on behalf of the state.
Defense.
James Owens on behalf of Miss Boone.
Tony Henderson for Miss Boone.
Kevin Beck on behalf of Sarah Boone.
All right, Ms. Boone is standing at counsel's table wearing a dark gray suit and maroon blouse. Let's go ahead and bring in our jury as Dr. Harper is here.
Uh-oh, we're looking at a laptop now. In our defense, he's holding it up in front of the camera. Just reviewed frame by frame Mr. Beck's footage from his laptop, and there is no point where you can do anything other than recognize that it's a Mac that he has up. You can't read any text. I've got it enlarged on the big screen. Nothing visible.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? All right, thank you. All could be seated. Again, members of the jury, if you could, just raise those hands, confirm you complied with the court's instructions. Record reflect all hands have been raised. All right, defense, at this time you may call your next witness.
We call Dr. Julie Harper.
This may be the final witness for defense. Much younger than I expected.
Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God? I do.
Doctor, good afternoon. Could you state and spell your name for the record for us?
Dr. Julie Harper, Harper.
Thank you. Counselor, you may inquire.
Thank you, Judge. Good afternoon.
Good afternoon.
I think you've already stated your name, but just introduce yourself to the jury.
My name is Dr. Julie Harper, and I'm a licensed psychologist.
Would you tell the jury your educational background?
I have an undergraduate degree from Oberlin College in biopsychology. I have a master's degree from University of Denver. I went on from my master's degree to earn a psychological doctorate. That's called a PsyD. That was also from University of Denver. In completing that education, I specialized in psychological assessment, which means I had extra coursework in that area of learning to administer psychological tests to other people. I completed an APA-approved internship at Washington State University, which means that I was matched, and that was my site to practice being a psychologist for a full year, and that was between 1999 and 2000. And following that, I turned in my dissertation, which was in the passing of power in couples relationships. I then graduated and started my postdoc work in Pullman, Washington. As part of becoming a psychologist, you have to have over 1,500 to 2,000 hours of supervised work as a psychologist. The person that supervised me was a forensic psychologist. So during that postdoc time, that was my introduction to forensic work while I worked at a community mental health center.
Dr. Harper,
how long have you been licensed?
I was first licensed in Washington State in 2002, so 22 years.
What type of position have you held as a psychologist?
Well, I was rehired at my internship site, so I worked at Washington State University College Counseling Center. I also worked 2 times at a community mental health center. The first time was in Pullman, Washington, and that was during the period of time where I was getting my postdoc hours completed, and then I stayed on after licensure. I also worked in Florida. When I came to Florida in 2005, I took a position in the Fort Walton Beach area at Bridgeway Center, which is a community mental health center. And while working there, I completed a variety of psychological assessments. I was directing the testing program. I also began working doing the Department of Juvenile Justice contract work for evaluating adolescents that had gotten into legal trouble and needed an assessment for consideration of program placement. I worked in that community mental health setting doing clinical assessments and the DJJ contract and Social Security evaluations, and continued that until about 2010. In 2010, I opened my own private practice, which is Northwest Florida Psychological Services. And in the beginning of the practice, it was a combined clinical and forensic practice, meaning that I spent a majority of time doing psychological assessments to answer questions from physicians about things like ADHD, depression, to make treatment recommendations. I had the therapy patients, and I also did, again, Social Security disability evaluations, so numerous kinds of assessments. And then over time, I began doing more and more forensic work, including receiving appointments from judges to do competency to stand trial evaluations, sanity at the time of the offense evaluations for Circuit 1 in Florida. And I continued to do the Department of Juvenile Justice contract briefly, but then that it came up for bid and I discontinued that contract. What I did is I slowly reduced my clinical practice, because when you do forensic psychology, it means you have to travel. Your individuals that you're seeing are not usually out in the community. A lot of times you have to see them in jail. So it's hard to maintain a therapy practice, and I scaled that back over time. Eventually, my practice became entirely forensic. And then in 2017, I took a job with the state of Georgia to be an evaluator full-time. I was working doing competency to stand trial and sanity at the time of the offense evaluations, and then assisting with risk assessments in the inpatient setting. I did that until 2021. At that time, my private practice was just it quieted down, of course, from COVID, and I was not in full-time practice, so I wished to return to full-time practice with my own company, and I did that in May of 2021. And since then, obviously the courts are busy again. We're all recovering from the COVID era and back to full-time practice.
Now, where do you live?
I live in Okaloosa County, and that is in the panhandle of Florida.
All right. And is that where your practice is currently?
Yes.
All right. Is it fair to say you travel the state to? Bless you. Is it fair to say you travel the state to do assessments or evaluations?
That's correct. I travel to a lot of cities throughout Florida, as far south as like Miami, and then of course working along.
Is it fair to say that you testify in various counties throughout the state?
Yes.
And I know that yesterday you were set to testify in Bay County, Panama City.
That's correct. I was testifying yesterday in a death penalty case in Bay County.
All right. And when you finished, you drove here?
Yes, I did.
My understanding is you got here after midnight.
Yes.
What other counties have you testified in?
Well, I've testified here in Orange County, in Miami-Dade, in Duval. It might be hard for me to list everywhere. Alachua, Escambia, Santa Rosa County, Walton County, Bay County, Washington.
So just so the jury understands, the nature of practice is you have to travel throughout the state.
Well, I do work in cases where the person is at risk of, succumbing to the death penalty. And so those cases require repeated evaluations in different vicinities. And so I have been, traveling to work on murder cases. There are psychologists, I suppose, that do forensic work that might just confine their work to one circuit or stay, but I actually broadly travel.
You said that your practice is now entirely forensic?
That's correct.
What you said? And you've testified about what kind of forensic work you do?
Yes. So as a forensic psychologist, sometimes I am tasked with testifying about something very specific. So, for instance, a person's ability to stand trial if they're knowledgeable and can go forward with their trial process. I've testified about a person's sanity at the time of the offense, meaning if they had a mental health condition that met the statute as to not being sane at the time of the offense. I've testified in sentencing hearings. I've been an expert witness for Department of Children and Families. I've testified in vocational rehabilitation hearings as their expert, in what's called social investigation. That's what they used to call custody evaluations. So in numerous capacities.
And would it be fair to say that a lot of times you're appointed by the court to provide the service that you provide and you're paid by the state?
That's correct.
What percentage of your work is where you're paid by the government to do the work?
I would say that the majority of my work comes through with that court-appointed funding. Percentage-wise, probably about 90%.
Okay. Now, I realize you testify on occasion by the state, but majority of your time, 90%, 95% of the time, you testify on the behalf of the defense?
Yes, the evaluation's complete, and either side can call me for testimony, and the majority of the time I'm called by defense.
And so you make a living by traveling the state, and generally the court system, I think they call it JAC, pays your fees.
So I make a living by performing work as a forensic psychologist, evaluating individuals, most of the time that are incarcerated in a prison or a jail setting, providing consultation to attorneys who might just have questions that would need a psychological expert to explain something to them. I also do fitness for duty evaluations for law enforcement, pre-employment evaluations for law enforcement and firefighters. So depending on the work that's needed, I do those.
Most of our clients are indigent.
How is a forensic psychological evaluation different than a regular psychological evaluation? Can you tell the jury?
Sure. So if any of us went into a psychologist's office and had an evaluation done, it would be most likely for treatment. So things like if you qualify for surgery or you're going to have treatment, maybe you've got a condition that you want therapy for. A psychological assessment is very helpful in identifying a diagnosis and then setting a course for treatment. A forensic psychological evaluation has many of the same procedures, but the aim is really different. The aim would be to answer some kind of legal question that is posed. So as an expert, I might be in the position to provide some education or experiential descriptions of something that a person might be suffering from to people that are going to make a decision. So for instance, if it's a competency evaluation, I would educate the fact finder. In that case, it would be a judge about what is wrong with the person or if they had any deficits at all or if they were competent to proceed. In a situation like this, a forensic psychological evaluation might be geared more to identifying, again, if there is a mental health condition present in the defendant I'm evaluating, and then to provide a jury with education about what I found in my evaluation.
How many forensic psychological evaluations have you conducted? Estimate.
So just as an estimate, it's clearly more than 4,000. I've been doing forensic psychological evaluations as far back as 2007.
Have you been qualified as an expert to testify in forensic psychologist in court as a forensic psychologist?
I have.
And you said you've testified for the prosecution?
Yes.
And you've testified for the defense?
Yes.
Is there any difference in the work that you do depending on who hires you? Which side?
Absolutely not. A forensic psychological evaluation is an objective assessment of what's going on with the person. So you should be performing the same kinds of procedures in doing the evaluation. It should not matter who's retained you. What you're trying to do is answer a question.
Are there times when you actually do an evaluation and assess an individual, but then you're not actually called to testify?
Yes, many times that's the case. You will provide your feedback to the attorney, and then it's up to the attorney to decide if there's anything in there that would be useful to them, or if they're pursuing a certain kind of information for the court, they would choose to call you for testimony.
Dr. Harper, do you recognize Sarah Boone at the defense table with Tony Henderson?
I do.
When did you first get involved with Miss Boone?
It would have been in around June of 2020. It was the first I heard of her case.
And what were you asked to do?
A comprehensive psychological evaluation of Ms. Boone.
And did you do that in Miss Boone's case?
I did.
Okay. Were you given materials to review?
I was.
Is that standard operating procedure?
Yes.
You assess the client individually, one-on-one, and then there are collateral evidence or material that you also consider?
Yes.
Can you tell the jury about that?
Yes. So in forensic work, there are a variety of documents that are usually available in assessing a defendant. In this case, for criminal court, you would see things like witness statements. There might be body cam footage or just more information about the offense itself. Sometimes there's an interrogation video. So you would get kind of the legal description of the offense and the things that have occurred. I also will often get educational records of a person, mental health records, hospital records, things of that nature that would describe their biopsychosocial history to me.
And you were given materials as it relates to Sarah Boone to review?
Yes, I have been.
How many times did you meet with Sarah Boone?
9 times.
All right. Can you tell the jury what you did as part of your evaluation of Sarah Boone?
Well, we had a clinical forensic interview in which I reviewed her background history, so her early childhood. I also assessed her with assessments, meaning I administered 3 psychological tests to her. I reviewed her prior mental health records, her interrogation video, some prior information about her legal history. So she had been previously arrested. I reviewed that as well. We had an opportunity to review the transcript of her interrogation video. So there were a variety of things that would be considered what I did with her.
Okay. So you considered some medical records?
Yes.
And did you also consider some records from George Torres's records?
I did see his hospital records.
Now, do you consider, in doing an assessment and forming any opinions, an individual like Ms. Boone's upbringing in terms of where they grew up and what their family environment was like?
Yes, that's part of gathering their background history, so biopsychosocial information.
And did you consider Ms. Boone's upbringing in forming any opinions?
I did.
Can you tell us a little bit about that?
Yes. So of her history, I found it pertinent that she was raised with...
Conduit 704.
Roach.
704. What's the 704 objection? Prejudicial? .704 is about the basis of opinion, testimony by experts. It states the facts or data that the expert uses to support their opinion do not need to be admissible in evidence if they're reasonably relied upon by experts in the field. Yeah, this is prejudice versus probative. Also addresses opinion testimony, stating it's not automatically objectionable if it embraces an ultimate issue. However, there are some exceptions.
The objection is sustained.
Ooh, not now.
Would you have considered, as part of her family background, whether or not some of her family members had passed away early in her life?
Objection, pleading, conduit 704.
Sustained.
You considered the entire family background and history without going into the details of what she said or what you learned from looking at records? I'm sorry?
Yes.
Okay. And did you consider her relationship with her mother as part of her psychological development?
Yes.
Now, do you believe that Sarah Boone does have some narcissistic traits?
I do.
She doesn't qualify or meet the criteria for that diagnosis, does she?
I did not diagnose her with that.
Right. Can you elaborate on or explain how you feel that Sarah Boone does have some narcissistic traits?
Well, in meeting with her as part of the evaluation, the narcissistic traits that I identified would have to do with, as she described, being a straight A student. She reiterated about her abilities, and I felt that that was evidence that she had low self-esteem, and her coping mechanism was to identify what made her stand out, and that would be consistent with a narcissistic trait.
Now, I know there's been reference in this case to a manual that all psychologists, all psychiatrists refer to. Do you have that manual with you?
I do.
And what is the name of that manual?
It is the Diagnostic and Statistical Manual of Mental Disorders, the text revision. So it's the DSM-5 text revision.
She brought it with her.
Now, Dr. Brannon testified earlier today, and there was some evidence relating to when you suffer from narcissism, there's a sense of grandiosity. But is that from this manual and your studies and your experience, where they require excessive admiration and whatnot, that there's a reason for that?
If I'm understanding your question, there's a criterion in narcissistic personality disorder related to that.
What I'm getting to is many times you may have these narcissistic traits, but really you suffer from very low self-esteem.
That's the underpinning of that criterion.
Would you explain that to the viewers?
If I'm allowed to reference the DSM, then I can explain it best.
Just don't read from it. Just
all right.
You need to review. If you need to read a paragraph and then explain it to the jury.
So based on the description in the DSM, if a person's self-esteem is very fragile and they have low self-esteem, they may require more outside admiration or even appear more grandiose in their abilities, because at root they don't feel secure and confident. And so it's what we would call a defense. And so that criterion is actually a way that a person tries to make themselves feel better.
Anything else you want to say about that issue?
Well, you asked me about why I didn't diagnose narcissistic personality disorder. And again, from the DSM,
Are there criteria?
There are criteria for each disorder.
And so when you're assessing someone, they have to meet all those criteria for you to form that opinion that they actually suffer from that disorder?
Well, the first, I guess, issue is, do they have the criterion that are listed? And then the second would be, is there a different mental health disorder that would better explain the criterion that you're seeing? The criterion within the DSM overlap considerably across disorders. And so there are some helpful guidelines within the DSM to remind you of that you may have what's called differential diagnosis. So if you're considering one thing, that you also are directed to look at other things. So that happened in this case, in this instance, that the DSM guided me to also look at other things.
But just for purposes, to make it clear, you did not diagnose her with narcissism, that disorder.
That's correct, because the DSM's description guided me that would not be an appropriate diagnosis.
Why did you not diagnose Ms. Boone with a personality disorder?
Well, first of all, it has to be a pervasive pattern of distorted relational abilities. So basically, if she is demonstrating in a variety of settings that she has these symptoms. And then secondarily, the diagnosis of post-traumatic stress disorder is listed when you're considering personality disorders. The DSM guides you that if there are personality changes that are associated with the exposure to a trauma, then you should consider post-traumatic stress disorder and not a personality disorder.
Have you diagnosed her with anything? And we'll elaborate on that, but through your assessment, have you diagnosed her with anything?
Yes, so she has a diagnosis of post-traumatic stress disorder. She has symptoms of anxiety that would be consistent with post-traumatic stress disorder. So that is an anxiety disorder.
And you feel like she suffers from post-traumatic stress?
I do.
Now, at the time of this incident, this event, we're talking February 23rd of 2020, you were aware that she did not have much family support?
Yes.
Doctor, why do you administer psychological testing?
Psychological testing allows an objective measurement of what the person's symptoms may be as compared to sort of an average. So if we can see what the average range on a standardized measure would be for any person, if there is an interpretable difference, that gives me clinical information. So it's not just relying on what the person has told me. I've got an objective measurement that I can compare to other people. And then I also administer psychological testing in a forensic evaluation to help assist me in making sure that the person is intending to put in good effort with me. In some forensic settings, a person may have a reason to present symptoms, like if they're in a custody evaluation, for instance, they might have a reason to minimize symptoms, or they may exaggerate something else. And so assessments as to the person's response to you and if they're validly participating are important.
So there are tests to see if you're faking or malingering or that type thing?
Right, and so you would call it feigning mental health symptoms when the person is either far exaggerating a symptom they do have, or if they're pretending to have a symptom that they do not actually have.
Okay. Now, as it relates to Sarah Boone, what type of psychological testing did you administer?
I administered the inventory of legal knowledge, and that is a test that has to do with whether or not she was validly participating regarding her understanding of the legal process. I also administered the Miller Forensic Assessment of Symptoms test.
Now, explain to the jury what that Miller forensic assessment of symptoms test is.
So that is also a test of feigning to identify if she's validly participating in the evaluation. So if she had endorsed psychological symptoms or psychiatric symptoms that would be unusual or not typical of a valid psychiatric patient.
What were the results of Ms. Boone's test on the Miller forensic?
She validly participated. There was no indication of any feigning or malingering.
And as far as the inventory of legal knowledge case, what were the results?
Again, she was validly participating, and she did not even come close to the cutoff that would put her in the range of feigning.
Can you tell the jury what the purpose of the clinician-administered post-traumatic stress disorder scale is?
Yes. So that would be considered a very useful assessment of post-traumatic stress disorder. It allows me to interview a person about exposure to a traumatic incident and then identify if there's a change in behavior that has occurred as a result of that exposure to trauma.
At the time that you administered that test, did Ms. Boone in fact have post-traumatic stress disorder?
Well,
or tell me the results.
Yes, so the results would be consistent with a person having post-traumatic stress disorder. I do not diagnose from one test. That wouldn't be appropriate, but it is consistent with the background and the symptoms that I had previously taken down during my evaluation of her. So the clinical portion, we go through symptoms, that was consistent with the outcome of that test.
And would this testing, all the testing, help you determine if Ms. Boone had a change in functioning from before the alleged trauma to after the alleged trauma? And I'm referring to the trauma. We're going to talk about what the trauma was, but the trauma was the intimate partner violence?
That's correct.
Okay. But would that testing help to determine if she had a change in functioning from that trauma of the intimate partner violence?
Absolutely.
And did you determine that she did suffer from trauma as a result of intimate partner violence?
That was my conclusion. Yes, that's my opinion.
Now, in considering all the available information, you don't just rely on what Ms. Boone tells you to make your decisions.
No, I don't. I do interview a person as part of the clinical forensic interview, of course, but I also consider things that are reported, like in the arrest narrative, witness statements, all of the medical records. So there are a variety of sources of information, collecting data points and reviewing those to arrive at a conclusion.
So you did review Ms. Boone's previous diagnoses in her history?
Yes.
Did you consider the previous diagnoses in arriving at your own?
I did, yes.
What did Ms. Boone, what had she been diagnosed with prior to you getting involved?
Objection 704 conduit.
Roach.
Interesting testimony here. Started out with asking about narcissism, and she admitted, yeah, Sarah Boone, she's got some of those narcissistic traits. As the lawyer walks up with his own copy of DSM in his hand, she's got those traits, but the manual says if there are signs of PTSD, if there's elements of PTSD in the past, then instead of calling it narcissism, you're supposed to call it PTSD. So for that reason, she's not diagnosed as a narcissist, even though she might check all the boxes. So PTSD is what she's going with here. Interesting. Trying to do this. Listen to our sneeze count. The bless you counter's up to 22 now, and working with Phil, TYO Toys, trying to get access to an upcoming case. All at the same time. I might need to hire somebody or clone myself. This is nuts. Why can't you have both? Great question. Why can't narcissism exist if PTSD also exists? Is it not look the same? Or you're saying the cause is different, thus we don't call it what we would otherwise. That excuses the murder for sure. Apparently there were two or more tests done on Sarah to determine if she was faking, lying basically in her results. And the results were far from the line. Absolutely not.
The objection is sustained.
You can't ask about the previous
but you would
diagnosis.
agree, and I think this is a fair question. You would consider prior...
What? Prior what?
Other experts who may have diagnosed her with something.
So I would definitely consider her mental health records, diagnoses previous clinicians may have arrived at the time when I diagnosed her myself.
Okay, and given the assessment that you did with Sarah Boone, and considering the totality and the time you spent with her and the other records, did you diagnose Sarah Boone with anything?
Yes, so post-traumatic stress disorder, it's my opinion at the time of the offense she had depression and she had an alcohol use disorder.
All right. I know we've talked about post-traumatic stress disorder. I don't know if I need to ask you anything further. I think the jury probably understands that. Is there anything else you wanted to add about that disorder?
I'm not sure what the jury's already been told about post-traumatic stress disorder, but in Sarah Boone's case specifically, because of enduring, she specifically noted the time that she was stabbed with the knife as being an extremely...
Sustained.
You have viewed...
Whoa.
Have you viewed some exhibits involving her being stabbed?
I think that we have had exhibits in common. I'm not sure what was admitted.
Have you seen the physical scar from Sarah Boone being stabbed in the back of the leg?
Yes, I've seen her scar.
Overruled.
Who's to strike that she's physically seen the scar?
Just generally, without getting specific. I think I've explained post-traumatic stress, but if there's something else the jury you believe the jury needs to know, but it's a sort of trauma that occurs as a result of one or more events.
Post-traumatic stress disorder is the psychological after effect of being exposed to a very significant stressor or cumulative stressors that make the person's behavior, thinking, and mood change. And so the change can include things like the person becomes hypervigilant, is easily startled, has trouble thinking, has trouble sleeping, so their body is in a state of agitation. It can also include changes in mood that would include irritability, difficulty relating to others, and that they might be resistant to trust easily. So those are all features.
They have trouble sleeping sometimes.
Yes.
Sleep deprivation is a real issue.
It's associated with things like nightmares and having trouble settling.
Now, you mentioned that you had diagnosed her with depression. Can you just give us a general understanding for the jury of depression?
So the persistent sad mood, including feelings of hopelessness, helplessness, having difficulty concentrating, sleep problems, changes in appetite, those would be typical of depression.
And Sarah Boone suffered from that?
Near the time of the offense, yes.
All right, can you explain to the jury alcohol use disorder? That's a fairly new name. That's 5 or 6 years ago. The manual came up with a different name.
It did, right. And so that would be, in layman's terms, you might call that alcoholism. It's a tendency to drink too much and then have some kind of consequence in your life as a result of your substance use.
And alcoholism can be depending on how much you drink and then how often you drink.
That's right.
All that is something that you would consider in diagnosing?
Yes.
The many people who suffer from alcohol use disorder, I don't know how to put this, are they in denial?
I would say that is one of the stages of alcohol use disorder and amenability to treatment. So in denial, it's because you do not want to acknowledge that there are consequences from your use, because in doing that, you might have to reduce how much you're using. So to deny means that you feel that you can continue your use without having to change that. So you want to maintain the access to the substance.
You don't have a problem.
That's right.
What is the difference between traits and a diagnosis?
Well, we all have personalities, and so you're going to have coping mechanisms that include personality styles. So, for instance, even though you might not be diagnosable as something, there are times when if you're upset, hurt, frustrated, you have a mood state that's unpleasant, you're going to deal with that by using some kind of coping mechanism. So the traits of personality disorders might be present in the way that you deal with inner pain, things that you don't like, feeling. So some people, for instance, if they feel uncomfortable, they may cling too much or become excessively bonded to try to escape a feeling that they don't like, and that might be a dependent personality trait. It doesn't necessarily mean that they have a personality disorder, because that would have to be pervasive across all the environments. But when stressed or upset or not feeling good, you're going to use some kind of coping mechanism, and that might be one of the criterion, for instance, of the personality disorder. You would call that a trait.
And is it your understanding that this trauma that one suffers from repeat domestic violence can cause one to be considered suffering from the syndrome, we call it battered spouse or battered woman syndrome?
Yes, so the diagnosable condition would be PTSD or post-traumatic stress disorder. That's how a clinician would label the response to trauma. The pattern between partners, the person's coping mechanism because of that trauma, that would be what's considered battered spouse or battered partner syndrome.
And you're aware that concept of being traumatized by the battered spouse syndrome or the post-traumatic stress is relevant to a self-defense case?
Yes.
In a criminal context?
Yes, I understand that.
Could you tell us a little bit about that?
Well, under the battered spouse syndrome, the person would experience a trauma or a situation in which they feared harm. And based on that fear of harm, they would react in a certain way that might not be understandable to other people. So their fear is based on the pattern of behavior between them and their partner. That might not be the case for another set of people.
Now, I know that Dr. Lenore Walker is the one who first uncovered this syndrome back in the 70s.
Her research study generated the term. She was interested in why battered women specifically at first, that was what was studied, didn't leave their partner because, of course, they're experiencing traumatic events, risks to their life, but then they didn't leave. So she undertook the original research study on that.
And just briefly touch on, because I know Dr. Brandon has this, there was 3 stages that Dr. Walker developed for that syndrome.
I think you're referring to phases that a person may go through, or the cycle of the relationship. That includes the tension building phase, in which there is the first instance that tension is building within the partner. There might be a change in tone, a signaling that there's a difference in agitation. The second is the true battering event, so something has happened between the partners that's violent in nature. And then third, there's the honeymoon phase, which is to keep the relationship intact. The batterer would engage in what's called honeymoon behaviors, like trying to repair the relationship, apologize, essentially keep the victim from departing from the relationship. So those are 3 phases.
And is it fair to say that psychologically the abuser, does alcohol often involved in the abuse?
Yes.
And as far as the victim that's getting abused, and you say it's a cycle, is the victim, when they go through that last stage, the honeymoon stage, are they thinking, okay, it's going to be better?
Yes, the hopefulness in that, trying to believe that the behavior has changed, that they're not going to be abused again, the hopefulness to maintain the relationship, to forgive. That's part of that last stage, phase 3, is maintaining the relationship.
I don't think I've asked this. Why would someone who has been exposed to intimate partner violence perceive the likelihood of a new violent event about to appear? Why would they perceive the likelihood of that violence differently than, say, a normal person?
Well, it speaks to the pattern. So any relationship will have its own special pattern, that you have things that only your partner knows about you, or certain looks that you give that mean something, and you learn that over time. So over a period of incidents, basically, the victim begins to perceive cues that would signal impending danger. Those cues could be really subtle, just a change in tone, or some small behavior that might not mean much to another person, but it has preceded other violent acts. So, for instance, if your husband decides that he is not going out that night, he might put on different clothes to stay home, and that could be a signal, like abuse and violence has occurred in his stay-at-home clothes, for instance. That might not mean much to another person because, again, it's specific to that dyad. Those 2 people know those patterns. So the victim may perceive a small or subtle change in their partner as a cue because they've become hyper-vigilant. The body knows when it's experienced a threat to itself, and it will take note. We record memories differently when we're at risk. So these subtle cues become very well memorized by somebody who's being victimized.
On this, and battered spouse syndrome is a subset of post-traumatic stress disorder, which you've diagnosed Sarah Boone with. When those personality changes occur, and they persist after an individual has been exposed to this extreme stress, is that when the diagnosis occurs?
The changes would be as a result of the pattern. The person experiences a change, like in their sleeping, in their hypervigilance. That's when you can diagnose it. So you can have a trauma or an experience of a scary incident, but it doesn't mean that you will absolutely have post-traumatic stress disorder. You have to have those reactive symptoms that would suggest that it's present.
In your opinion, and I know you've gone over this event with Sarah Boone, this February 23rd, 2020 event, is your opinion that she was suffering from battered spouse syndrome at the time of that event?
Yes, she had the patterns ingrained in her behavior that would be typical of a victim who's responding to traumatic events in a predictable way. So that would fit that.
And it's fair to say that because of the intimate partner and the prior violence, that you would have a heightened sense of when danger or was about to occur.
Yes.
When a threat was about to occur.
Yes.
A threat of danger.
That's right.
Now I want to talk about placating the abuser. A victim placating an abuser. Are there predictive cues which an abuser may exhibit to a victim that result in a high level of anxiety arousal in which the battered woman may attempt to reduce through several different means to delay the beating? Can you explain that?
Yes. So the phase of the relationship that starts with that tension building, that is a jumping off point potentially. So if you can stop the escalation, you might stay in phase one for a period of time. Phase one being that tension building phase and trying to reduce it and not allow it to escalate. So placating the abuser might include distraction. It could include substance use. It could include a change of scenery. There are a lot of things that a partner will learn to do so that they don't have the escalation into an abusive event, if possible. Doesn't always stop it.
Now, in reviewing all of the data, all the reports, medical records, and whatever reports you considered, videotape that you may have watched, as it relates specifically to Sarah Boone, are her words her power?
Her words, I would say, are the weapon that she has.
Explain that to the jury.
In reviewing the available videos that I had to review, you would see that when Ms. Boone is very stressed, when she's experiencing a high level of anxiety, she becomes short in her tone. You can hear that in her voice. There's a strain. Sharper words come out. I think that that is the way that she would try to respond to Mr. Torres. You can hear that sharpness in her voice when she's very stressed out.
Now, would you agree that victims may exhibit a range of behaviors when they're suffering from intimate partner violence?
Yes.
Self-isolation?
Yes.
Suicidal thoughts?
Yes.
Substance abuse?
Yes.
And there are often physical signs of injury such as bruising?
That's correct.
Chronic fatigue?
Yes.
Learned helplessness?
Yes.
Can you tell I know Dr. Brandon spoke on it, but could you tell us a little bit about that?
So learned helplessness is when you start to form the opinion that nothing's going to make any difference. It comes originally from an animal study in which dogs were shocked, and the research study indicated that even when dogs were given an opportunity to escape the environment in which they were being shocked, if they were shocked enough, they just stopped trying to escape. So even though they had an opportunity to do so, they did not do that. That's called learned helplessness. It's the idea or belief that what your actions are going to do are not going to make a difference, so don't try.
What are intrusive memories?
Intrusive memories are an element of post-traumatic stress disorder in which you don't want to be thinking of a traumatic event, but it intrudes on something else you're trying to do. Like maybe you're folding socks or something like that, just doing something mindless, and that's what takes over your thought process. It's not something that you're trying to think about. We could plan what we're thinking about, or sometimes if you're just having this intrusive experience, that's not what you were intending to think about at all.
I have thoughts on
this. Conditions that someone may suffer when they have this syndrome of battered spouse?
Yes.
I know there can be triggers that bring on these memories. Am I correct?
That's correct.
Are there also symptoms of this syndrome where like in the alcoholism, where you have denial that you're in the middle of this cycle?
Well, as part of the relationship, there's an element of pleasure. Like you have early on in the relationship something that binds you together. So you're remembering that, you're hoping for that, even though the repeated cycle is going through the phases 1, 2, and 3, you keep hoping for elements of that honeymoon phase, wishing that it was better. So it is like denial. You're imagining the way it used to be. You have a recollection of that person showing you positive behaviors, and you're hoping for that. I also think it is typical for victims to not reveal to other people that the abuse is going on, and it seems like denial. In other words, your coworkers ask you, like, are you okay? Did something happen to you? You're not likely to disclose that. That looks a lot like denial. It is a denial in public of some of the private issues that you're having in your relationship. And that's because it's embarrassing. It's revealing a loss of control to other people. It's revealing that things aren't perfect. You might even get feedback that you should leave your partner, and that's unwanted because you're already having that, concern in your own mind about it. And so, it seems like denial on the outside to hide it.
Would you agree many people who suffer from this, they're minimizing what is happening to them?
Yes.
And they're numbing their emotions to it.
Well, to stay present and keep that relationship, it's very difficult for a lot of people because they're experiencing physical and emotional harm. So they want to numb it, because numbing it means that you can keep that relatedness no matter how bad it's getting.
Does some people with this syndrome disassociate?
Relevance.
Approach.
Okay, while they approach, I have a couple thoughts here. First of all, this witness is good at what she does. I don't question that she is very educated in her field, very experienced, and the things she's saying about domestic abuse, about the PTSD, about the trauma, they're real. Okay, they're not false. She's not making things up. So this is true, and these are patterns that are seen. My problem is, I'm having a hard time with her saying that Sarah wasn't lying about anything.
Objection to relevance is overruled.
When she lied to almost everyone.
Do you agree that battered women often develop the defense mechanism of being able to psychologically detach from their body during a traumatic experience?
Some people do experience that.
I'm just going to list some of the symptoms that you find in battered spouse women, and just to see if you agree with these. We talked about intrusive memories and flashbacks of the past traumatic events. You agree with that?
Yes.
The severe anxiety and hypervigilance.
Yes.
The panic attacks.
That is sometimes present. It depends on how the person experiences anxiety, but some do have panic attacks.
Very low self-esteem.
Yes.
Poor body image.
Sometimes.
Feeling that they have no control.
Yes.
Sexual dysfunction?
It can be, particularly if the trauma includes sexualized attacks.
Short-term memory problems and confusion?
Yes, that's part of PTSD sometimes.
And they can actually have physical health problems from the chronic stress and physical violence.
That's correct.
Fear.
Yes.
Constant fear.
That is correct.
Now, the abusive partner, the abuser, part of the abuse would be hitting, kicking, punching, choking, burning, and biting.
Approach.
I'm still stuck on those two tests that she did that said they detect feigning, and there was no sign of feigning. I want to know. I want to know if this witness watched the videos. I want to know if the witness watched the interrogation video, if she watched the body cam video on scene. I think there's a lot more, and I realize, denial, lying, it can be one of the symptoms. We can all wrap this up and say and explain it that way. The state The state has to take the gloves off on cross on this witness. This is not a witness you have to treat with kid gloves. This is a witness that you can throw full speed, full power punches at because she's a professional, because she's an expert. She should be able to handle all the questions and cross-examination that's brought her way. And they need to bring it if they want to secure a conviction here. They can't have another lackluster cross on a witness. We'll see what happens here. Hopefully we get cross tonight. Might even start rebuttal tonight. Depends on, we've got to hurry. We've got to wrap things up really quick. But she said she watched the videos. %90 of her work is done with indigent defendants.
You may proceed, sir.
Sounds like the objection.
I'm asking about common things that occur by the abusive partner towards the victim that create this intimate partner violence or create this syndrome in the woman. Hitting.
Yes, that could be an overt act.
Kicking.
Yes.
Punching.
Yes.
Choking.
Yes.
Burning.
Yes.
Using weapons to hurt you.
Yes.
A knife.
Correct.
Curtain rod.
Yes.
Threatening to hurt you, your children, or your pets.
Yes.
Belittling and humiliating you.
That's correct.
Taking your car keys.
That would be considered a form of control, so yes.
Controlling your money.
Yes.
Control where you go and who you see.
Correct.
And who you can talk to.
That's right.
Force you to have sex when you don't want to.
Yes.
Stalking you.
Yes.
Slapping you.
Correct.
You agree victims that suffer from this abuse experience feelings of anger?
Yes, that can be in some of the phases.
Sadness?
Yes.
Hopelessness?
Yes.
Worthlessness?
Correct.
Intense feelings of fear?
Yes.
Abusers have a tendency to have low self-esteem themselves.
Overruled.
Abusers.
Overruled.
The abuser can have low self-esteem himself.
Yes.
Have a desire for power and control.
Correct.
Have a tendency to use alcohol or drugs.
Yes.
Abusers oftentimes have temper.
That's correct.
Become jealous easily.
Yes.
Very possessive.
Can be.
The victims can suffer from severe psychological distress.
That's correct.
Is that what Sarah Boone suffered from?
Yes.
Yes, sir.
I'm showing you Exhibit 14. This is 5 photographs. Did you watch the video of the TV, the Battered TV?
I did.
You considered that in your analysis and your diagnosis?
Yes, I did.
And I'm going to show you some pictures. Exhibit 12. I believe she's testified that this is where the curtain line. Are you familiar with that?
Yes.
Exhibit 11. Are you familiar with this photograph over here?
Yes.
Exhibit 10, which is her arm. Are you familiar with that photograph?
Yes.
Exhibit 9, picture of the bloody knee. Exhibit 8, picture of her black eye.
Yes, I've seen these.
Picture, Exhibit 7, picture of her, Sarah's lips and looks like her eyebrow.
Yes.
And this is a composite Exhibit 6, which is of the stab to her leg. Are you familiar with those?
Yes.
And I don't know if you've seen this Exhibit 5 is where she spilled some soup as a result of his behavior.
I'm not sure if I've seen this photo, but I've seen a medical record associated with that.
Of that burn?
Yes.
Exhibit 4?
Yes.
Stay with that. Looks like Exhibit 3. She was slapped on the tongue.
Yes.
Exhibit 2. Picture of bruising in this book.
Yes.
Did you consider all those photographs informing your opinions that you've expressed here today as it relates to Sarah Boone?
Yes, under the substantiation that she has indeed experienced past instances of intimate partner violence against her.
Is it fair to say that it takes time, a number of times, to visit with someone like this to build trust?
Yes, traumatized people are slow to disclose information. You have to build rapport. You have to make sure that they experience you discussing other things without an emotional reaction. They feel easily judged, as we mentioned, have defensive denial, things like that. So you need to build good rapport in doing an assessment with somebody that's experienced trauma.
So a lot of times they're very slow to open up and tell you about the abuse.
That is correct. That's not the issue, or they're fine. So oftentimes I'll have an evaluation request come from an attorney who's having difficulty interacting with their client, and then ultimately it's the result of trauma.
Now, I know that you viewed everything, and I know you've seen her 9 times. Is there did you feel like you had enough time? Was 9 visits enough time for you to feel like you had enough time and information to form the opinions that you've expressed here today and given to this group?
Yes.
That's all the questions I have.
Okay. Any cross-examination?
Yes, sir. Good afternoon, Dr. Harper.
Good afternoon.
So you have done some evaluation work on battered spouse syndrome for a prosecution in the past?
No.
All right. Have you done insanity evaluations for the prosecution in the past?
I have been called to testify about that.
So you understand when the government obtains a court order for their expert to come in and do an evaluation, it's for one evaluation, correct?
I believe that you're saying that the government can retain their own expert, yes.
No, man, what I'm talking about is you just went through that you had 9 visits with Ms. Boone, correct?
I did, yes.
And that was over the course of 8 different days, because 2 of those visits were morning and afternoon sessions, correct?
That's right.
And what we are trying to help you have the jury understand is that when you get hired by the government and the court gives you an order to go evaluate somebody, you get one crack at the apple. government. Is that your understanding from your past work working for the government?
No, that's not always correct. There are many instances in competency evaluations where evaluators will request additional visits if they cannot determine their opinion on the first visit.
All right. Specifically when it comes to an affirmative defense, such as battered spouse evidence and insanity, what is your understanding and your expertise?
What is my understanding of the issue? Oh.
Judge, the question...
Legal objection.
Objection?
Legal grounds.
He asked a question about battered spouse and insanity.
He can't get a legal objection. Legal objection should be one or two words. Hearsay, relevance. This is something of that nature. The judge does not want speaking objections in front of the jury. The state came out swinging initially and is attacking the policy for hiring an expert, saying you get one shot, you do one analysis. Objection sustained.
When it comes to an affirmative defense such as battered spouse syndrome being used for self-defense or, not and, insanity, it requires a court order for the state to go have an evaluator go, right?
Yes.
All right. Now, what are the agreed upon criteria for battered spouse syndrome?
Well, you would evaluate if the person is indeed suffering from a behavioral response, like a mental disorder. So, first of all, has the person demonstrated that they've got a behavioral change? And is it in response to a violent act? Do they perceive threat where they've been exposed in the past? So, a pattern of violence that has repeated.
Does control over another person in an intimate relationship have anything to do with it?
Yes, it can.
Does isolation have anything to do with it?
Yes.
And by control, I mean controlling who you go see, who you hang out with, so on and so forth?
Yes.
And could it involve controlling personal items of the other person as well?
Yes, it can.
So that's what I'm asking. Like in the DSM-5 TR, I believe you pulled up narcissistic personality disorder.
Yes.
And so when you do that, it pulls up and it says there's 9 criteria, and 5 of those criteria must be met to make a diagnosis for narcissistic personality disorder, correct?
That's right.
Now, battered spouse syndrome is not recognized by the DSM-5 TR, correct?
No, it's not a diagnosis. You wouldn't use it as a diagnosis.
And what I'm asking is, even though we haven't written it down in the Diagnostic Statistical Manual, and I mean the, like the Ohio State University or something, is it written down anywhere? Can one psychologist or psychiatrist rely upon a recipe or a list of criteria that everyone else would be using in your field as well?
There is no standardized approach you must follow. In other words, sometimes if we have a statute, for instance, it would identify what we must investigate. It doesn't exist like that. There's no statute directing it.
And there's nothing written down anywhere that says, of these 9 criteria, these things must exist. Controlling your partner, isolating your partner, beating your partner, so on and so forth. Correct?
That's right.
All right. Now, this kind of abuse can come in the form of emotional or mental abuse outside completely of physical or sexual abuse, correct?
So that is a component. You can have extreme mental abuse occur of a person, yes.
And if that person responds to that environmental stimuli of whatever it is the partner is saying or doing to them, they may internally view that as traumatic.
They could.
Or they may not.
That's right.
It's entirely possible for 2 people to be in a 3.5-year relationship that has physical violence and neither one of them feel traumatized by that. Is that correct?
That's right. If they have enough supportive or positive experiences that would negate that ratio, so of positive to negative, they may feel okay.
And a man can be subjected to this sort of trauma, whether it be physical, emotional, or sexual, by an intimate partner as well, correct?
That's right.
And it's basically it's unique to each relationship, right?
That is right.
But trauma is in the eye of the beholder. Is that fair? Whether a negative experience traumatizes somebody is going to be in the eye of the person who experienced that stimuli, correct?
I only partially agree with you. It's a complicated answer because some of the manifestations of trauma are behavioral. So for instance, when I evaluate veterans who have returned and they may not know that they've been traumatized, their bodily responses that include like difficulty concentrating, they can't sleep, they're hypervigilant. The PTSD diagnosis encompasses outward manifestations. So even though they don't acknowledge trauma, you can still identify it as a clinician.
But still, somebody like a homicide detective or a homicide prosecutor can go to scenes where there are dead bodies, go to autopsies where there are dead bodies, and not walk away with any trauma, correct? Whereas somebody else might.
Right. The environmental, cues for that person, and also working with law enforcement, they become seasoned to micro traumas. So the first, almost every police officer can remember their first dead body they've seen. So it's in their memory. And then they become accustomed to seeing gruesome scenes. They have an increased tolerance over time because it's part of their job. It may not be part of their intimate relationship that they have with someone else.
Now, you brought up veterans. Is something common with PTSD with veterans something like firecrackers may set them off because it reminds them of acts of war?
That's right.
You're not suggesting to the jury today that if somebody who returns with PTSD from service and hears firecrackers is justified in going outside and just shooting bullets everywhere, correct?
No, that's not what I said.
I'm not saying you did.
Okay.
What this battered spouse syndrome evidence is helpful for is not that subjective mindset, but rather helping to explain the objective circumstances that are presented to somebody and how it might be different from somebody with those experiences. They may view something objectively different.
I partially disagree with your question because I would say that there are incidents or actual events between partners that would be a factual thing, something has happened. And then the person subjectively experiences that as, intrusive or controlling or traumatic. So that is the person's felt or subjective experience. The objective part is what happened.
But again, as a forensic psychologist, you're familiar with the justified use of force instruction, correct?
I'm not a lawyer, though, so I'm aware of it, but I cannot debate fine points of that with you. I'm sorry.
I'm just helping. I'm trying to understand what you said before, because there's a subjective component, whether or not a person believes subjectively that they need to use some sort of force, deadly or non-deadly. You agree with that, correct?
I do.
And then there's also a second component that it's objectively reasonable to the ordinary person to use force, correct?
I understand what you're saying, yes.
And what I believe I heard you mention earlier about battered spouse syndrome was originally it was meant to help understand why people stay in these relationships.
Originally, yes.
Because it may not just be intuitive to somebody who doesn't understand these things why somebody who is abused time and time and time again would remain in that relationship, correct?
That's right.
And again, and I know you're not a lawyer, but if the law has evolved about retreat and not having to retreat and so on and so forth, that kind of changes some of the lens of this, correct?
Judge, I'm going to object.
Approach. Question withdrawn. May proceed.
That was a quick one.
All right.
Didn't even get to talk.
So you would agree that, hypothetically, if somebody is running down their partner, saying negative things about them, telling them they're unattractive, telling them things that would potentially hurt their feelings, that could be an element of control of a verbally abusive relationship.
It could.
Okay. Propping one up, hypothetically saying, I'm the best thing that has ever happened to you, you'll never do better than me. Is that a potential component of the control that one in an abusive relationship might exert over an intimate partner?
Yes, to try to not encourage their partner to leave them. Yeah.
Considering gifts, hypothetically, that one partner has given to another partner, but considering it still to be your property because you gave it to them, is that a form of potential exertion of control over an intimate partner when you give somebody hypothetically a bike but still consider it your own bike?
I mean, I don't think that's strong evidence of that. I think that it does happen in relationships and people do that in general, but I wouldn't say that's like really specific to this.
How about hypothetically exerting control over your intimate partner's identification papers, such as a birth certificate?
So that can happen. People will hide things that are required for work, for instance, like your driver's license or things like that.
Now, I'm asking yes or no questions. If Mr. Owens would like you to elaborate further, he's going to have that opportunity in a little bit.
Now he's gunning for it. Here we go.
Hypothetically, if one partner destroys another partner's belongings, is that a potential example of exerting control in a relationship?
Yes.
Thank you. Hypothetically, is threatening to or actually using legal process as a threat against your intimate partner in a potential indicia of controlling your partner? For instance, X, Y, or Z, or I'm going to get you arrested.
Indicia.
Yes, I would agree that happens.
Now, I assume you would agree that this cycle of violence that we've described, the tension building, the blow up, and then the honeymoon phase, you would agree that just one of those cycles could be enough to give somebody a traumatic experience if they took it as a traumatic experience.
Yes.
The defendant described her first date with Mr. Torres to you, did she not?
She did.
And at the time of this first date, they had obviously just met that night at a bar, correct?
Right.
They were not financially intertwined, correct?
That's right.
They shared no children in common?
That's right.
They did not live together?
Correct.
And after this description that she provided you, which included him smashing her phone, correct?
Yes.
Hitting her, first time she'd ever been hit in her life, correct?
Yes.
And making her crouch in like a fetal position on the porch for several hours to the point where it hurt her back, correct?
Yes.
Threatened to sodomize her.
Correct.
And she described that she was all bruised up, correct?
Yes.
After that, this is the first time she had ever met him, correct?
I believe so.
There was a second date, correct?
Yes.
Despite not having any
date.
of that intertwinement that we went through prior to this description, correct?
That's right.
Now, it is possible under what we've discussed, right? Just that quick one date can be that buildup of tension and blow up, correct?
Yes.
But it's different, hypothetically, than saying a spouse who is financially dependent on his or her other spouse in a 20-year marriage with a house full of kids than a first date, correct? You would agree in severity, in the intertwinement, there's a difference.
There's a difference in intertwinement. The pattern can be exactly the same.
Maybe she should have swiped left on that one instead of swiped right.
Now, of course, there are many different reasons why somebody will stay in a relationship that, when perceived from the outside, others would say is abusive, correct?
That's right.
The defendant described that she felt like she was making Mr. Torres a better person, correct?
That's right.
A better father, correct?
Yes. Right.
A better ex-husband?
With phone calls, yes.
And she would tell him to call his children.
That's right.
Make sure that he sent them Christmas gifts.
Yes.
And make sure he sent his ex-wife money when she asked, correct?
Yes.
So you would agree those are indicia, or indicators, sorry.
Understand.
I know you know them. That perhaps she wasn't necessarily financially dependent on Mr. Torres, correct? I'm not saying conclusion, but those are indicators. If you're saying, please spend your money elsewhere, that I don't need your money, correct?
No, because even if there was money that was needed by Ms. Boone, her tendency to put the needs of her partner before her would direct her to do exactly that, like make him better, make him have the availability to visit his children, send them presents, even if she's the one that needed the money.
And in her perspective, Mr. Torres needed her to do this to make him a better person, correct?
I believe that, yes.
How many years of her adult life did she describe working?
I don't think she gave it a specific quantity. We just went through a variety of her jobs that she had in the past.
And, you know, she was low 40s when she met you 4 years ago?
That's right.
So she had been 18 for probably about 24 years. Did she give you a 24, right? 24 plus 18, 42?
Oh, you said for 24 years, and that's why I was confused. You can't be 18 for 24 years, but 24 years ago, I would agree.
Did her work history kind of flesh out to be 24 years is what I'm asking?
I'm not certain.
And at the time, in the apartment in 2020, she had not been working, correct?
That's right.
And had not been working for some time.
That's right.
And what she was doing was living off of the settlement that she had been bought out of with her husband. It was lump sum plus $1,000 a month in alimony and $100 a month in child support, correct?
Yes.
And it was Mr. Torres who would work, correct?
He worked at Ace Hardware, I think.
When he would show up.
Right.
Sometimes he didn't show up, is what she indicated, correct?
Yes.
Because of his drinking problems.
Yes.
Did she describe to you, well, let me strike that. She did describe to you one instance, at least, where violence occurred in front of her child, correct?
Yes.
And that her child had gone to school and reported it, correct?
Yes.
And you understand as a forensic psychologist that teachers are mandatory reporters, correct?
That's right.
Did you review any DCF records in this case?
No, I didn't receive any DCF records.
Did Ms. Boone ever indicate to you at any point in time she became too afraid to let Lucas come over to the house?
Yes, there were times where she would ask Mr. Boone, so Brian Boone, to not bring him there.
And Mr. Boone was aware of this because she would say things like that, correct?
Yes.
And at different times she told you that she would go over to Mr. Boone's house to escape the violence of Mr. Torres.
That's right.
And February 24th of 2020, the child was scheduled to be picked up by Miss Boone, correct?
That's right.
Despite everything that she was aware of and what Mr. Brian Boone was aware of, correct?
Right.
And you saw in her police interview that she swore on the life of her son that she was telling them the truth, correct?
Yes.
Yes.
Object.
Approach.
I object. He's destroying our case. I don't know what the objection is there. This is evidence that's been, the jury has heard. She did say, I swear on the life of my son, I'm telling you the truth. We know she was lying in there. She admitted to lying in it. That's how we know. Sarah's been writing a lot.
Objection sustained.
Objection sustained. Win for defense.
She swore on her son's life that it was not intentional that she ended up killing Mr. Torres, correct?
That.
I object.
Approach.
Apparently, we need to get it word for word. Let's see if do we need to play the tape again? Not intentional. Do we have to count another not intentional? Let's see if we bring the counter on. Takes a minute to switch here. There we go. We added to the not intentional counter up to 62 now. It's hard to run two counters at once.
Objection sustained. Question is stricken. Members of the jury, questions are not evidence, and you're not to give them any weight whatsoever. Mr. J, you may proceed.
She's, quote unquote, swore on her child's life that it was not intentional. Just that. Correct?
Before I answer, I'd like you to direct me to that part of her interview. So
I'll strike it with you. It's on video.
It's on video. It's
Some
been
of Ms.
struck.
Boone's diagnoses predated her relationship with Mr. Torres, correct?
Yes.
And so when diagnoses predate a violent intimate partner relationship, there is an independent cause, even though they may then later contribute to the phenomenon we see, correct?
Well, I wouldn't say that all mental disorders have an independent cause.
Okay.
Sometimes they're spontaneous or biological in nature.
Well, let's talk about hers. I mean, you're familiar with her prior diagnoses, and you went through her childhood, so on and so forth, correct?
I did.
So she was bringing some things with her prior to Mr. Torres' relationship, correct?
She had
Also, yes or no, ma'am?
Yes, she did.
Thank you. You reviewed some Advent health records, correct, of hers?
Yes.
And some Aspire records of hers, correct?
Yes.
And you would agree that there are times in the Advent health records where she goes to the hospital and then leaves before getting treated, correct?
Yes.
And there is a time when she goes to the hospital where she is described, their words not mine, as having ETOH on board.
Yes.
Do you understand what ETOH means?
In a medical record, you would use that shorthand for alcohol.
Or ethanol, right?
Yes.
Drinking alcohol, not the other stuff.
Correct.
Not rubbing alcohol.
And in the records that you reviewed from Aspire, she came with complaints of depression in January of 2018, correct?
That's right.
And ethanol, or alcohol, is a central nervous system depressant, correct?
Yes.
And I know you're a psychologist, not a psychiatrist, so let me know if I'm pushing you too far and you're not going to answer. But you are familiar generally with the effects ethanol has on. And in your professional life or personal, for instance, hey, I only drink 2 drinks a day. All right, well, are they 64-ounce mugs of beer or are they 12-ounce? So are you familiar in that context?
It might be a question I would ask during evaluation. What are you referring to? Is it a mixed drink? Is it a shot? Like, I try to identify that.
And you ever ask if somebody says they drink 2 glasses of wine, well, how big are the glasses of wine?
Sometimes.
And is your understanding that 5 ounces is the standard serving of wine since it's about 12% alcohol?
I'm not sure what the standard size is, but I would ask regarding like a wine glass.
Right. And in January of 2018, when she came in crying and complaining of symptoms consistent with depression, she had a blood alcohol level of 0.165, correct?
I believe so.
And in October of 2018, when she ended up going to Aspire, when she was found stumbling by police, she had a breath alcohol of 0.185.
I'm reacting to your description of her stumbling by police. I know she approached police for help. So
there have been 2 sets of records, but I believe you may have the same set that I received on September 27th of 24. Can you turn to page 21 of 57 of the Aspire records?
mine aren't numbered, but I will.
May I approach the witness?
Yes.
assume she's found it. Someone has to talk first. Judge uses this moment to teach the law students.
What I'm showing you is what is page 2157 on records from Aspire that was provided to me by the defense on September 27th, 2024. And just at the top, you can read the first or the fourth lines.
All right.
All right.
Judge, I would ask that she be allowed to read that entire paragraph under the rule of completeness.
Approach.
All right, so now this is interesting because you can use almost anything to refresh a witness's recollection, right? We've heard examples of a peanut butter sandwich being used to refresh a witness's recollection. Here they're refreshing her recollection, and there's been an objection citing the rule of completeness. Rule of completeness typically comes in when one side wishes to introduce just a portion of an item of evidence, say, for instance, a video. They just have a 3-second clip of the defendant punching the victim in the face. And that's all they bring in. They say under the rule of completeness, we'd like the whole video, which shows the defendant getting clobbered by this guy and then finally throwing one punch at the end. The rule of completeness it gives you context. I guess she can read the whole thing. The first date. I thought we heard a recounting of a first date from Sarah where he was charming, they met, it was awesome, he was fun, he was handsome. Did I hear the wrong first date rendition? Because apparently it was different. It was different than what I thought. I thought they met at a bar. It was great. He was funny. Was that all the same first date? Guys, we're seeing internet issues across the board, like solar flare type internet. I don't know. Did we have a astronomy guy? That
you may proceed, Mr. J.
Solar flare going on.
All right. October of 2018, there was a second visit to Aspire, and that was based upon her being found stumbling by law enforcement with a .185, correct?
She walked up. Okay. So I'd have to say no, the way you phrased the question.
Ma'am, Boone was stumbling due to her level of impairment, paren .185.
Yes, I would agree.
Is that part of the records you relied upon?
Yes.
Thank you.
Wow, she's losing credibility there, trying to parse words and eliminate something that was in the record.
When you talked to Ms. Boone about that, she kind of just described an event of June of 2018 and blurring those two events, did she not?
No, she told me she had two different Baker Acts.
Did she describe it as being June of 2018?
I'll have to reference my interview note to find that if you would like me to.
No.
Whoa. Interview notes? 2 Baker Acts.
Do you remember giving a deposition on October 1st at the state attorney's office downstairs?
I do.
And at that point in time, and I'll ask the opposing party, you want me to show her prior statement before I ask her about it?
I think she's got a deposition.
Do you have your transcript?
I do.
Okay.
Just
so for the record,
Baker Act's involuntary hold.
Line 16 and 17.
Or also known as anything Broken Baker does. That's a Baker Act.
Yes, I'm with you.
Okay. She described that as June of 2018?
That's what I said in my deposition, that she was describing her experience in June of 18.
And she described this experience as going to the hospital to find a pastor, correct?
Yes.
And ends up going to what we call Lakeside Den and Aspire now, right?
Yes.
And then what you described was she was talking about more of the violence that occurred specifically regarding a significant episode of Jorge driving her roughly in the car, so on and so forth, correct?
Yes.
All right. Those were two separate incidences. January, when she came looking for the pastor, correct?
So I'm just clarifying that there's a record that we started with this conversation from October of 2018, and there is a description of her trying to go to the hospital to seek a counselor. So those are two different instances.
In January of 2018, when she went to the hospital crying and signs of depression,
bless you,
she indicated that was because her husband and son had gone out of town and she was feeling lonely and sad about having lost her job a few weeks earlier, right?
There were numerous stressors there, yes.
Nothing mentioned about any problems with somebody named Mr. Jorge or George Torres, correct?
You're talking about January?
Yes, ma'am.
I think this witness is stalling a little bit to try to break up the line of questioning. We're not going to get to cross tonight at this rate. I mean, we're not going to get to rebuttal tonight at this rate. We're on cross right now.
So the hospital records are not referencing her relationship with George on the January date.
Now, in talking about February 23rd, 2020 with Ms. Boone, you talked to her about that on several occasions, correct?
I did.
And part of one of those conversations, at least, was about an incident that she indicated had happened the night before February 23rd, 2020, correct?
Yes.
And she indicated and told you that she had been dragged down the stairs the night before the Suitcase incident, correct?
That's right.
And in part of your review of this case, you reviewed all the crime scene photos, correct?
Yes.
And those include photographs of Ms. Boone, correct?
Yes.
And were there any indications in the photographs of injuries on her consistent with being dragged down the stairs of carpet?
I didn't see inside her scalp, so I didn't see photos of inside, her hair follicles and this area of her head. On her outward body, there were no indications of that.
And did you ask her how it was that she was injured during this dragging down the stairs?
I don't think I went through specific injuries to her, no.
Do you agree that alcohol intoxication affects the credibility of a historian that's providing history to you, a patient or a client?
If they're actively intoxicated, yes.
We had talked, you and Mr. Owens, had talked about narcissistic personality disorder earlier.
Yes.
And that is a recognized diagnosis in the DSM-5-TR?
That's right.
And there's 9 of those, correct? 9 traits?
You're talking about the criterion of narcissistic personality disorder? Yes.
Let me go through and see which ones
Page
Sarah
761 on
exhibits.
your hard copy.
Thank you.
No post-it note on this page.
All right.
Was I close? I have a digital copy.
760, but that's fine.
One of the criteria is has a grandiose sense of self-importance, for example, exaggerates achievements and talents, expects to be recognized as superior without commensurate achievements, correct?
Yes.
2 is preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love, correct?
Yes.
3, belief that he or she is special and unique and can only be understood by or should associate with other special or high-status people, or institutions, correct?
So 3, just caveat, it says believes, not belief, but the rest of what you said I agree with is the criterion.
4, requires excessive admiration.
Yes.
5, has a sense of entitlement, unreasonable expectations of especially favorable treatment or automatic compliance with his or her expectations, correct?
Yes.
6, is interpersonally exploitive, takes advantage of others to achieve his or her own ends, correct?
Is interpersonally exploitative. I agree.
7, lacks empathy, is unwilling to recognize or identify with the feelings and needs of others, correct?
Yes.
8, is often envious of others or believes that others are envious of him or her, correct?
Yes.
9, shows arrogant or haughty behaviors or attitudes.
Yes.
Well, I think that was a clean sweep.
Now,
We have a winner.
you believe that she has traits of that disorder, correct?
Yes.
Grandiose sense of self-importance?
There are indications that she feels like that or has expressed that before.
So that's a yes.
Yes.
Preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love?
No.
Do you remember going to the state attorney's office on October 1st of 2024 and giving a deposition?
I do.
And it was in front of a court reporter like Madam Court Reporter here?
Yes.
And you swore to tell the truth, the whole truth, and nothing but the truth, correct?
Impeached her.
And referring to page 89,
Crank the volume.
lines 18 through 20. Let me know when you're ready. Are you ready?
Yes.
Did you give the following answer to the following question? Preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love? And your answer was yes?
I did answer yes there.
Oops.
She does not, in your estimation, does not believe that she is special and unique and can only associate with high-status people, correct?
No.
Does not require excessive admiration, correct?
Correct.
Does have a sense of entitlement?
Yes.
Is not interpersonally exploitive?
Correct. She is not.
And when discussing whether or not she lacked empathy or was unwilling to recognize or identify with the feelings or needs of others, you indicated that that might be the case, but it's not intentional.
In other words, she's not aware if she's inconveniencing others.
So there was 3 of those traits, correct?
Yes.
Not 5, which would be required, correct? For a diagnosis of the personality disorder.
If that were the correct diagnosis, you would need 5.
All right. During your conversations with Ms. Boone, the defendant in this case, she explained to you that cheating to her means when Mr. Torres would look at pornography, correct?
Correct.
Not a real-life woman, right?
No, not that he was engaging in sexual intercourse with actual women.
Part of the records that you did not review were the text messages that were part of the phone extraction of her phone device, correct?
That's right.
You indicated in your conversation with Mr. Owens that some of the traits that are commonly seen in abusers would be control, jealousy, easily angered.
This could be, yes.
What other traits just common for abusers?
Being a person who segregates their victim away from other sources of support, somebody that exhibits coercive control, meaning that they would prevent the person from engaging in activities that would be independent, so restricting their ability to have independent, like life, job, money, things like that, that would be supportive of them being left, for instance. Other things would be using emotional expressions like rage to cause a physiological reaction in another person. So those could be additional descriptions.
Specifically, the materials you reviewed. I just want to make sure we're on the same page. Paperwork from prior cases involving Mr. Torres and Ms. Boone.
Yes.
Medical records for Mr. Torres.
That's right.
The medical and Aspire records for Ms. Boone that we've discussed.
Yes.
The crime scene photos from the incident in February.
That's right.
Pages 1 through 413 in discovery in this case.
Right.
A photograph of a suitcase and 2 videos involving a suitcase.
That's right.
And additional videos on that phone, correct?
Yes.
Such as baseball bat smashing the TV?
That's part of it, yes.
And then did you review any other videos where there's conversations between Ms. Boone and Mr. Torres?
Yes.
We haven't seen those other videos.
One prior 911 call?
Yes.
Now today you had indicated that you had reviewed the photographs from some prior incidents of violence, correct?
Yes.
When is it that you did that? Is that recently?
No, there are photos included with the
prior case packages?
Case packages. Thank you. I'm not sure what to call it. So
that's fine.
All right.
All right. And did you review any body worn camera from those prior case packages?
No, I did not. I didn't have that.
Anything else that you reviewed that I've not covered?
Are you speaking of documents only?
Yes. Materials other than your 9 visits with Ms. Boone.
All right.
She has a list of everything that she's covered.
Just checking with the pointers I prepared for today. I don't know if, I guess that would be part of the discovery. The investigative report is within those 413 pages.
Did you interview anybody else personally besides Ms. Boone?
Yes.
Who else did you personally interview?
Melissa Sexton.
All right. Anybody else?
No.
You didn't interview Brian Boone, correct?
I did not.
You did not interview their child in common, correct?
No.
And you didn't review the phone text messages extracted from her device, correct?
No, I didn't.
Did you review any records from the jail?
No.
And
Judge.
Yes.
I wonder what the objection is here. Covering material that she did or did not. Did we haven't heard anything from the jail, right? We haven't got any jail records. That might have been the problem, saying there are records from the jail, because we do have some behavior records that the jail has admitted on the case file that have been released publicly about arguments she's got into or problems that she's caused in the jail. Wonder if those were excluded. T. Shelby, welcome to the gallery. Brand new member. Everyone welcome T. Shelby. Thank you very much. You're here now. You can never leave. It's a one-way door. I don't know. I thought I'm not the expert here, but I thought we saw more check marks in that criteria list for narcissism than the expert or even the defense came up with. What about when she says it's not fair? It's not fair to her. Isn't she asking special treatment there? So it's not fair that you arrest me and trick me and all that. I would have thought that would have met that check mark. Sarah's done a lot of writing today. A couple notes have been passed as well, but just mostly just intense writing. That's delusion. And Nicole, yes, we do. We know more about this than the jury. That's why the judge is doing his job, making rulings on what evidence is admissible and what isn't. Jury has not seen any of her letters to the judge, nor will they. Katie Bug, thank you for the super sticker. Love the popcorn. There's another note going back. Nicole. Wrong answers only. What did Sarah write on the note that she just passed? Mr. J is doing well. He's sort of stuck the witness to yes and no answers when she was shaping the answers in a particular manner that benefits defense. So that's been good. I'm going to take a quick peek at that. Hang on. I can't show you that. I apologize. Can't show you the cameraman is not intending to catch that, but Sarah lifted up a paper that was readable. Sorry, I have to follow the court orders too, so I can't go back and show you that. Long sidebar here. Witness is just chilling. It just happened. It was after Sarah passed the note. It was not, when do I get my phone back? No, it was not. Bite me. I can show you while they're doing this. This is my desk, and right here, I'll show you. Right here, we have a recorder, a hyperdeck recording to NAS storage underneath, and I can control that right here with slow motion. I can rewind and watch frame by frame if I wanted to, something that happened. So I just instantly can go back and do a replay. It's like instant replay in sports. I have that machine here. It helps sometimes when things happen. The feed is a little choppy. I'm seeing other major networks having the same problem. So either it's a solar flare or something. But so far it hasn't dropped out, but I've had moments of just blurriness and a couple buffering, so I do apologize for that. But it looks like it's like East Coast wide right now. Bob, I do not have a telestrator yet, but I'm looking at one.
The objection is sustained in part and overruled in part.
You testified earlier in the normal course of practice of forensic psychology and psychiatry, you all do rely upon the diagnoses of other experts, correct?
You can inform my opinion, yes.
And you have not reviewed any electronic communications in the form of text regarding Ms. Boone's case, correct?
No, I did not.
Or recorded phone calls of any type, correct?
Well, 911.
Other than that?
No, other than that.
Now, let's talk about the February 23rd, 2020. She told you that they didn't really have anything going on to do that particular day, correct?
Yes.
It was a Sunday, correct?
Yes.
Did some chores, and then as a reward, they could rest after doing those chores, correct?
Right.
She indicated to you that she and Mr. Torres did not begin drinking till about 4 p.m., correct?
I'll have to reference.
Page 36 of your deposition, if you care to use that.
Great, thank you. 36?
Yes, ma'am.
All right, I'm with you. Around 4 p.m.
And you reviewed the crime scene photos of this case, correct?
I did.
That included receipts for some purchases that were made at Publix on February 22nd and 23rd, correct?
That's right.
And one of those receipts was a purchase for a 1.5 liter bottle of Woodbridge Chardonnay at 12:17 p.m. on February 23rd, correct?
Yes.
Did you question her about the inconsistency of them having purchased a bottle of wine at 12:17 that afternoon and not start drinking until 4 p.m.?
No.
And did she tell you that they had any wine left over from the day before that they consumed that day?
At some point, I'm not sure if it was the day that I was going through this line by line with you in my deposition, but I am aware, yes, that there was an unfinished bottle of wine from some other date.
And then, as the receipt showed, there was 2 additional bottles of 1.5 liters of wine purchased at 12:17 p.m. and about 5:30 p.m. on the 23rd, correct?
Right.
And were you aware of approximately how much Ms. Boone, the defendant, weighed at the time of this offense, February 23rd, 2020?
Around 100 pounds.
And in the first 413 pages of discovery, I believe, was the autopsy report, correct?
Right.
And so you're aware that Mr. Torres was 103 pounds at his death?
Yes.
Do you take into account this alcohol consumption when evaluating what Ms. Boone is telling you about the events of the day?
Yes.
Did she tell you whether or not she was intoxicated by the amount of alcohol she consumed that day?
Please silence your cell phone.
Okay, who was that? Okay.
May proceed.
So she did not describe herself as intoxicated originally when we discussed this. So
So the answer is no. She did not describe herself as
intoxicated, right.
Hypothetically, if she had told the jury that she was intoxicated at the time of the offense, would that affect your evaluation of her credibility in the history she provided you?
No, because that was also my opinion.
Did she indicate to you in describing the events of February 23rd, 2020, that there was any point in time she just simply did not remember?
Yes.
What points in time were those?
So she did not remember taking the videos of the suitcase, or the incident in the suitcase, until she was at the interrogation room, I guess, and then they were going through them with her. Then she recalled that.
I'm talking about specifically with you. Did she indicate that there were any portions of the night that, or day or night, that she did not remember?
I can't recall anything specifically right now.
Hypothetically, if she had indicated to the jury that she did not remember the 9 or 10 minutes immediately preceding the first video being taken, would that be inconsistent with what she told you then?
No.
Well, she didn't indicate to you that she forgot any part of the night, right?
Right. She just didn't say that. So.
Would it affect your evaluation of what she told you about the events of February 23rd, 2020, if she hypothetically has testified that she did not remember 10 minutes before the videos?
Not really, no, because the event and the course of events that she narrated to me occurred over several hours. So when you interview somebody about circumstances of an offense, it's the usual for someone to not remember every single minute for hours at a time. I can't imagine that anybody's memory could hold that much unless they have like photographic memory or something.
I'm not asking about hours and hours of, itemization of her day's events. We're talking about the 20 minutes of the offense. Does that affect the weight that you give her history she provided you? Just yes or no?
No.
Now, what she indicated to you was the day had been going well. It was fun and games, correct?
Yes.
Conflict-free?
To her, she said it was a good day. So That's what she told me.
She said it was a good day?
Yes.
And there comes a point in time where the activities turn toward hide and seek, correct?
Yes.
And she goes up to the shower?
Right.
And when she comes down from the shower, that's when Mr. Torres is in this suitcase, correct?
Getting into it.
And she goes over to the suitcase and zips it, correct?
Yes.
And did she describe whether it was 100% zipped to you or just a certain percentage?
She said that it wasn't zipped all the way.
Okay. And still then, that was funny to the two of them at first, correct?
That's right.
And then there came a point in time where Mr. Torres was getting mad about being zipped in the suitcase.
She told me that he was getting mad.
Yes. And that, in turn, made her mad.
That's right.
What Mr. Torres was saying was, I can't breathe, correct?
That is what's recorded on the video.
Well, I'm asking you about what you reported her saying.
Well, what made her mad was not that he was saying he couldn't breathe. It's what he was saying that was making her mad.
Well, what else was he saying?
At the time, she said that he said something that was making her mad. And so that's the extent of what we talked about at that moment.
So you didn't elaborate what something was that made her mad, correct?
Right. She said he said something that made her mad, and that started making her mad.
You didn't find it important to learn what specifically he said that made her mad, correct?
I don't agree that I didn't find it important.
Okay. Then explain. Why wouldn't you ask that question?
Because as a person who is traumatized is describing their experience, as a trained clinician, you will allow open-ended discussion of that experience. And so it's not an interrogation. You don't go asking confrontational questions at the time of their first narration.
Well, you had 9 visits with her. Did you follow up on your 9th visit?
I asked her different questions about.
Did you ever ask her?
Confrontational.
Did you ever ask her specifically in any of your 9 visits with her what it was that he said that made her mad?
No.
She never described him doing anything to make her mad, but it was words, correct?
Right.
And once she got mad, she decided that she was going to leave him in there for 2 minutes.
That's right.
Not 3, not 1, but 2, correct?
That's what she said.
And the reason she was doing that was because she wanted him to understand how it feels to be choked and what she had experienced.
That's right.
Did you ask her why she didn't let him out of the suitcase after 2 minutes?
Yes, I did actually ask her that.
And what did she say?
Well, she thought that he could get out himself. That's one thing. She said that when she was able to unzip it, it was not some significant thing. She was able to unzip it easily. So she said it never occurred to her that he couldn't get out.
You may proceed.
The judge just opened up
And you reviewed the still photograph
video
of the suitcase as well as the 2 videos.
Right.
And did you
Was the judge
understand
watching
what
the
the
video?
metadata or what the timestamps were for each of those items?
I'm sure when I reviewed it, I saw the timestamp. Yeah.
Would you agree that 20 minutes is 10 times as long as 2 minutes?
I would.
And if Mr. Torres had not been able to get himself out of the suitcase within 20 minutes, she didn't indicate that she let him out, correct?
She did not.
She described to you, Ms. Boone being the she, that she was helpful to the police?
Yes.
Do you agree with that assessment that she was helpful to the police?
In the sense that she was having conversations with them without counsel, I would consider that helpful to the police.
Do you think lying to the police is helpful to the police's investigation?
No.
Do you agree that she was not truthful with them?
Yes, I think that I would agree with that.
And when she described getting Mr. Torres out of the suitcase, she described stretching his little legs?
Yes.
And she stated to you there was no fight that day, correct?
That's right.
Just wanted him to be uncomfortable.
I need to clarify. Physical fight.
Right.
Yes.
Just wanted him to be uncomfortable.
Yes.
Correct? And then there was a description of a bat and her using it to nudge, right?
Poke.
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 And so do we agree that that means like poking out like this as opposed to swinging it like you're a baseball hitter?
I would agree with you.
And you reviewed the autopsy report, correct?
I believe so.
Did you get an opportunity to review the autopsy photos?
Yes.
Did you question her when she said that she only poked him with the bat?
No.
Not in any of your 9 visits?
Did I question her about whether... Can you just repeat the question? I want to make sure I'm answering it correctly.
Yes, ma'am.
Okay.
Did you ever, in considering the autopsy report and the autopsy photographs that you reviewed,
yes,
when she said that she nudged or poked with the baseball bat, did you ever question her about that, given the severity of his injuries?
So to answer correctly, I did question her about how she used the bat.
Okay.
She reiterated that she poked and she gestured what she meant. So I did question her about that.
And did you have any questions about that history she relayed to you, given the other evidence in this case that you reviewed?
Lorraine, welcome. Thank you so much.
Just in contrast to the interrogation video. So that...
It didn't contrast to the autopsy photographs or report?
Judge, I object.
Roach.
I object. Defense is struggling to list that legal objection. Yes, that sound we heard, because we could see the witness turn to the judge, be like, why is that happening? That's where the sound was coming from. And I believe that sound was from the judge's laptop as he connected to a live stream. Don't know whose. We were not talking at the time, so we can't tell if it's ours.
You may proceed.
Did she indicate all this nudging or poking with the bat was done while he was inside the suitcase?
Yes.
She never told you that there was any nudging or poking with the bat when he was outside of the suitcase?
Correct.
She indicated that she ended up flipping the suitcase over face down?
That's right.
Did she tell you about Mr. Torres calling his brother earlier that evening?
No.
Did she ever give you a history about a loud boom occurring inside of her townhouse that evening?
No.
And you never had the opportunity, obviously, to interview Mr. Torres about these things, correct?
Of course not. No.
No other questions?
Any redirect examination?
Yes. Yes, redirect.
Yes, sir.
Briefly. Single page of notes off a legal pad.
The state attorney talked to you about power and control, that an abusive partner will use power and control over the victim in a intimate partner violence situation?
Yes.
Threatening someone's dogs, is that an example of someone using control?
Yes.
Taking car keys from the other party, is that an example of control?
If they're withholding, yes.
Taking a phone and withholding a phone?
Yes.
A debit card?
Yes.
Destroying a home, TVs, putting holes in the wall?
Yes.
Not helping pay the rent and other bills?
So I would say that could be withholding, that could go under coercive control of another person.
What about violating a court order to have no contact with the person?
Yes.
That's all the questions.
Thank you.
Wow.
Can this witness be released?
I think the judge was checking the live stream to see if something was shown that shouldn't be. He was probably made aware that Sarah Boone's note.
Collect all your stuff, ma'am. No worries.
Sorry.
No apologies necessary.
Judge says take your junk. Collect all your stuff. OG Sean White, 10 months. Congratulations. Thank you. Looks like the judge has a tablet or computer open from the way that his body's illuminated and his chin's illuminated with a screen. I think he has a video monitor right in front of him facing up. Does defense rest now? Waiting for Mr. Owens to come back in. Here he comes.
Yes.
Quick approach. Attorney's front and center. Up we go. Sandra Oliver, thank you very much. 16 months. Sorry if I can click on the right one. There we go. Jinx, thank you. Sandra Oliver, thank you very much. Member of the gallery. Love the Orange Courthouse. Thank you. Thank you, Sandra. Appreciate it. You're zoomed in tight so as to not see the prosecutor's screen. Hello, defense.
All right, members of the jury, it is 4:01. At this point in time, we're going to go ahead and take that afternoon break. I got a couple things I got to address with counsel as well, so maybe a little bit longer, but we'll bring you back in as promptly as possible. Again, same instruction I've given you before. Please don't conduct any independent investigation or research. It's the person, places, things, or charge involved in this case, and do not have any conversations amongst yourselves or anyone else about that. We'll bring you back in as promptly as possible. Thank you.
All right.
Red Finch, thank you very much. Today is a beautiful day. Congratulations on 60 months. Wouldn't be the same without you here. Thank you for your continued support of the program. Let's see if the judge wants to take a break or first address some issues.
Y'all can be seated. Let's go ahead and take a recess, a comfort break for any of us, and then we can address any argument with regard to the any other evidence that the defense may be seeking. Let's come back here in about 10 minutes, so 4:13. Okay? All right, thank you. We'll be in a short recess.
Quick 10-minute break for the judge. I just want to review and see if he's had that laptop open all day. Let me... You want to watch with me? This will make your head spin. Here we go. This is that's what we're going to do. We're going to pause and just do a speed rewind and look for when the judge had the laptop open. Let's see right here. There was one. Okay, the laptop's open there. Looks like it's been open the whole time. So that's not a new computer on his desk. Like Judge Schroeder, who did bring us up on his desk and watch us live during court. It did sound like we had the witness audio. Yeah, same laptop on the desk. All right. It did sound like we had the witness audio on the overhead or on the judge's microphone. So I do think he was watching the live stream, possibly to ensure, because we do know there was a complaint from the state that the cameraman zooming in on our computers, or someone zooming in on our computers. It could be that somebody posted a picture online or something like that. But it could have been just to ensure that everything was being done properly. He was playing Candy Crush. Owens is struggling to verbalize his objections. All he can get out is objection, and the judge will say approach if he knows what it is and knows they have to fight it out in front of him. That's fine. If the judge doesn't see an objection there, he'll say, "What's the legal argument?" And Mr. Owens is like, and he instead starts listing like argument in front of the jury, and that's when the judge says approach. So he's struggled with the objections a little bit. Judge should be worried about local network security and the projector issue. That is a major, major security flaw. You have a jury in there. Got to be super careful. Holly Mack just gifted 5 memberships. Congratulations to the 5 new winners, who are Paul Young's Jet J, Luna Matador, Mello's Arrest Warrant, and Ruth Whaley. Congratulations. Welcome. Welcome out of slow mode. It is true. Becoming a member escapes you from the purgatory that is slow mode. You get to chat to your heart's content. Christy G. You stood there with arms open, Christy G, waiting for the membership, and it missed you entirely. It'll happen. It'll happen. Just wait. Anne-Marie says, I'm starting to think she may walk free. I told you yesterday, as soon as they got this this battered spouse threshold met, that they could open the door to all these pictures, that at that point I saw a pathway to an acquittal. Not a sure one, but a pathway. And it's there's a, like, what do they say in Dumb and Dumber? So you're saying there's a chance. There's a chance. There's a chance here. Bug Dugger gifted a membership. Thank you very much, Dodie for Goaty. Thank you. or Dottie for Gotti, I think is how it is, was the winner there. Nurse for God gifted 5 memberships. Thank you as well. Let's see. Couch Juror, Pretty Eyes T, My Crime Time, Kitty, and So Marcy Sows. Welcome to the world of green. Lisa says, I finally bought a membership yesterday. I'll just eat less. I will say, if you're buying a membership, it is cheaper to do it on a computer than on an iOS device. It doesn't change anything as far as support for the channel goes. It's just iOS takes a bigger cut, so they're more expensive on that platform. So try to help where I can. Moonfox Studios just received a membership courtesy of Katie Bug. Thank you, Moonfox and Katie Bug, for being here. Marilyn Skoll, love being here. 20 months, one of our OGs. Thank you. Krista OG gifted 5 memberships. Wow, they're flying. French Fry, Deborah Simmons, Michelle Flegel, Shanna M. Richard, and Arlie's Holloway all gifted memberships. You guys are going nuts over there. Let's see. You have no phone? Don't think so. My phone's not ringing. Not sure why. It's because I got the new phone, and I think AT&T has an outage right now, and I do have AT&T. I did check down with our live view down in Florida. We are showing that we have a solid T-Mobile, a solid Verizon, and 2 pretty solid AT&T connections down there. So it's looking good. Amber, your call came right through. Of course, you have.
It came through. Well, no, I called burner number, not the real number.
You didn't call the hotline, the red phone. Krista Johnson, thank you for gifting a membership. Also, we have Virginia Little gifted 5 memberships. Thank you, Virginia. And Bug Duggar, I can't read all the names that are receiving these. They're going too fast.
It's going nuts with gifted membership.
Let's see. Linda says, I missed part of the testimony. Did it help the state or defense? I would say on cross-examination, the witness, the expert witness, Julie Harper, lost some credibility. She definitely skipped over questions that she probably should have asked, and minimized any, the presence of alcohol and what that might have done to Sarah Boone's memory of the occasion. Just really sort of looked at everything with rose-colored glasses in Sarah Boone's favor across the whole thing. And that now we understand why she said, there was no sign of feigning. There was no faking. She wasn't lying about anything because she looked at everything in the light most favorable to Sarah Boone. Instead of questioning and really digging and finding the meat of the matter and where the truth lies. It's pronounced Doty.
Can I push back on that?
Maybe. What? Do you want to run it by me first?
I think there's a difference between malingering and faking bad, basically, or faking good. And
Mrs. Aria wants to talk to you guys. Can you wear headphones? We've got a couple minutes.
Okay, I have not seen. Oh, I can't hear me. Can you hear me?
Well, hi, Mrs. R.A.
Hey, Amber.
I forgot I was here. I was waiting.
I don't know if I'm on mic right now.
Hang on, you are. Hang on.
Okay.
You are.
All right, so I haven't watched all of this, but I think that there is. Oh, now I'm really loud in my ears. I think that there is a difference between saying, I believe that she's feigning and I believe that she lies. Now, it sounds like there shouldn't be a difference there, but there is. There's a distinct difference that when you say I lie, you're talking about I took the dog out when you didn't really take the dog out. That would be a lie. Feigning would be I'm pretending to have a mental disorder that I do not have, or I'm pretending to not have a mental disorder that I do have. That would be feigning. It is specific to faking or not, or faking to either have or to not have a mental disorder. That would be feigning, whereas lying can just be a part of actually having a disorder.
But it's like a subsection of lying, right? So a lie is something where you do or say or don't say something with the intent to deceive, right?
Sure, she's lying, but there is a difference. I'm just saying that when this doctor is saying she's not feigning, she's, can you turn me down? I'm like so loud.
I don't know which headphone you're in. How about this one? Is that better?
Am I quieter? Yeah, that's better. Thanks. when she says she's not feigning, she's talking specifically about she is not faking good or faking bad, that I am getting a correct diagnosis based on her behavior, part of which is that she lies in normal life. So in this case, lying actually means you're not feigning, because lying is a part of this diagnosis. Does that make sense?
I see it differently.
But you're wrong.
Well, before I sleep on the couch tonight, let me tell you why I think that.
All right, let's hear it.
Sarah Boone lied to everyone.
Can I hang up now?
Amber,
I don't
welcome.
want to be rude.
I didn't know you were here.
Amber, did you call to say something? I apologize. I keep leaving you up, just sitting out
No,
there.
I was calling to test the burner phone.
Oh, it's working. Thank you, Amber. Appreciate that. I'll let you go. All right. Bye-bye.
Did I just talk over her? Is that
No,
what I did?
she just was quiet. She was just quiet.
Sorry. Okay.
She lies to everybody. She
Yes,
lies,
that's
lies,
true.
lies. She lied to the police. She lied on the body cam. She lied in the first in-car interrogation. She lied at the in-studio, or like the in-station interrogation. She told a different story on the stand under oath in pre-trial. It's constantly been changing. It's like a moving target with her. And the way that this witness described it was that there was no feigning. There was no faking.
I'm sorry.
Okay, so here's...
Donnie wants to say hi to you. Hang on one second.
Okay.
Donnie, this is a rare moment. I'm letting you talk directly to my wife.
He's mocked me directly in chat.
I just wanted to make sure, because been since in the past timeout procedures that I was in, I was thought maybe the phone. I wasn't, but I'm good now. I hear myself and that's it.
The phone's working. See you, Donnie.
Okay, so here, let me make sure that I'm hearing you properly.
Sue McDonald says, Mrs. Ari is correct. You're conflating two things, apples and oranges.
That was way more succinctly said than I said it.
Well, even more succinct, sorry, Mrs. Ari is wrong here.
But she's wrong. No, okay, so here's the thing. What I'm hearing you say, and correct me if I'm wrong here, you're saying she lies all the time, therefore she's a liar. Is that what you're saying?
No, this witness basically said, I went and observed her 9 times. I evaluated her 9 times and found this to be the case. This is the truth because she told me. And
no, okay, so this is where we disagree.
Call from.
I feel...
Is the phone working? To accept, press 1. To send a voice...
Hold on, let's let Mrs. Ari talk just for a second. The phone is working.
I'm basically just going to reiterate my point that I made before, that in some diagnoses, the fact that somebody is lying strengthens the diagnosis. So she can acknowledge...
Say like narcissism.
Yes, so she can...
But she said it didn't apply.
Okay, and the reason that did not apply is because there are so many different types of medical problems that are very close to each other, and so they're getting into the nitpicky weeds.
She said she had
You are interrupting me.
She doesn't even know when she's lying.
She might not. She does tend to lie so much. I think that is a real possibility. But my point is that the doctor looks at that and says, that helps me form my diagnosis. I recognize that she is lying, which gives me the information to give the correct diagnosis. I am able to do so because she cannot feign not lying. The fact that she lies so much shows me that this diagnosis is correct.
PTSD.
Okay. Whew. All right. I can get into this one, but I feel like I need to give... Who's on the phone?
Welcome. Who's on the phone? Thank you very much.
Julianne Weaver.
Julianne, how are you doing? What's your
I'm
thoughts on
good.
this?
How are you? I just think that it's very... I have a lot of thoughts on it. It's been going on for years, right? But it's hard as a domestic victim, right? To focus on, you murdered that guy. I'm just saying, we know that's what happened.
Right.
And that's what makes it...
She
her lying and just lying and lying and lying. I mean, we all see that you're lying.
Right. Okay. So this is just common sense, right? I'm in the weeds on this one, but if you get out of it and you take the big overview, it's like, okay, you got the right diagnosis. Who cares? She's a liar. Well, the reason it matters is because as a domestic violence victim yourself, right? Did I hear that properly?
Right.
Okay.
Right. I think so.
It's going to... You think so? I'm sure you're right.
If you think so, it probably counts.
If you look at me in chat, I can't spell that well, so...
Sorry, I lost my train of thought.
Let me say what I was going to say. Here's the thing. She says about everything. She has a story, or she has a reason, or she has an explanation. We don't smoke. We have to smoke outside because we can't smoke in the house. And then we see the video or the picture of like the ashtray full of cigarettes. Did you smoke in the house? Oh yeah, sometimes. I don't drink. I can't get drunk. Oh, I'm blaming the alcohol. I'm never touching alcohol again. The lies are so absurd and they're so extreme. They are
the hiding
both
seek
extremes.
thing got me. The hiding seek.
Yeah, tag you're it. Hide and seek. Let's both hide. Go.
Scott, we are playing wrong.
Yeah, we're going to do Sarah Boone's house rules next time we play hide and seek.
No, we sure are not.
Well, I just was calling to make sure the phone's working, and I hope you guys have a wonderful day.
Thank you for the call. Appreciate it. We'll see you.
Has the phone not been working? Why is everybody saying that?
AT&T's had some issues today.
Oh,
so
okay.
We'll turn the phone off for now.
Okay, so to why this matters, why this even should be brought up when you look at somebody and you say they're lying, like with Murdaugh. I looked at Murdaugh, I was like, he's a liar. He announced he's a liar. He lied then. He's lying now. The answer is clear. He lied. That was very clear for me. Now, this is slightly different because when you talk to somebody or examine them or whatever who is an emotionally abusive or physically abusive, okay, if somebody is in a physically abusive relationship, they are also being emotionally abused. So if they are being abused, their ability to think gets twisted. Gets very messed up. If they thought clearly, they would get out of that situation. If they thought clearly, they would not get in the first place. If they thought clearly, they would do a lot of things differently. I can't remember what this had to do with lying. I don't think it has anything to do with lying.
Going back to what you said initially, it's just that lying and feigning are different. Feigning is the faking to make somebody believe something's,
right. You can fake bad.
You've got like I go to the doctor and I feign an illness so I can get drugs type thing. That would be a feigning.
Do they give you drugs?
That's why people doctor shop.
You can doctor shop?
Oh, if you can afford it. Okay, judge is back. We need to go.
Okay.
All right, we're back on the record. Case number 2020, CF 2603, State of Florida versus Sarah Boone. Appearances for the state.
Dave Castor on behalf of the state. William J.
Defense.
James Owens for the defense.
Tony Henderson for Sarah Boone.
Kevin Beck for Sarah Boone.
All right. Ms. Boone is seated at counsel's table wearing the same dark gray suit and maroon blouse from this morning. Mr. Owens, are there any other matters we need to address before you rest in the presence of our jury?
Yes.
Yes, sir.
Mr. Henderson.
Mr. Henderson, you're up. This is where you talk.
Yes. Judge, there's two orders that I'm going to be requesting the court to take judicial notice of under 90.202 sub 6, and the orders are no contact. I have copies of the certified copies of the orders. May I approach?
Yes. State, have you seen them?
What is
Doesn't change my
this?
position.
Understand, but you have seen them.
I have not.
You have not seen them. Okay.
Doesn't change my position.
Understood. Okay. You can bring them on up.
No contact orders. Why are they getting a no contact order here? Clearly it's going to be...
Thank you, sir.
Sarah Boone as one of the parties.
Court has been provided no contact orders issued in case number 2019 MM5062 on or about June 16, 2019, and a no contact order in case number 2019 MM5114 issued on or about June 19, 2019. Both cases styled State of Florida versus Torres George Jr. Let me hear any argument as to the judicial notice from you, Mr. Henderson.
Judge, I think they're relevant. I think just from the testimony of redirect of Dr. Harper saying that an element of control and control is talked about greatly by the state when I point out things hypothetically that they refer to. They refer to them as hypothetically. However, they refer to things that they're developing on Ms. Boone. These show that there were in fact orders, and the orders were for no contact. So these are elements of control in relation to George Torres.
Don't think you can get any quieter than that.
Response.
So in regards to the judicial notice aspect, We don't dispute that that can be a substitute for authenticity. However, they're not relevant, they're not admissible. They contain statements that were made by people who are not testifying. Just because an expert relies on something doesn't mean that it's admissible. What happened during redirect with Mr. Owens was he was asking, what are the hypothetical things that we rely upon in making these determinations as an expert about whether there's battered spouse syndrome or not. So one of the many inadmissible things that he mentioned was pretrial orders of no contact. So it's fine. The expert can certainly rely on the fact that there may have been pretrial contact orders or no contact orders that were involved in this case, and she considered that. That doesn't make them admissible. There has been testimony, I believe, from Ms. Moon that there was pretrial no contact orders and violations of them. It's not a fact in dispute. It just that doesn't mean that the paperwork comes in as evidence. So that's our objection: is it's irrelevant and hearsay. Just because an expert relies on inadmissible evidence doesn't make it admissible.
What's your response to hearsay?
Judge, I think under the as to hearsay, I think the statute takes care of that itself, because it says that the court can take judicial notice. So that's the foundationary part, and it's not hearsay. It's an order of the court. We're in a case where we've gotten in evidence of past domestic abuse. There was evidence started with the state about control. And these are things of control. And I'm sure the state's going to, in rebuttal, they're going to come up with things that they feel either by body cam or any other evidence that shows her exercising control. This shows Mr. Torres exercising control. It is very relevant.
But how's it not hearsay? Just because it's a court record, it's still out of court statement. Certainly being offered for the truth of the matter asserted, no contact order.
Judge, that's why we have the thing that the court could take judicial notice of. There are certain things that court...
But the case law says you can't utilize judicial notice to get around hearsay.
Ooh. You have to get around hearsay.
I know 9202 says that I may take judicial notice. 9203 says that upon sufficient notice being provided, which the state is conceding based on their argument, the court shall take judicial notice of items identified in 9202. But my question is, the case law, as identified in Professor Earhart's treatise, specifically says in Dufour v. State, 69 7th 3rd, 235,
case law,
which specifically talks about notice of judicial documents in a court file, that doesn't get you around hearsay. So what's your response?
Let me go through hearsay in my mind again.
You're fine. Take your time.
Go through the exceptions to hearsay. Which one can you argue? Because you have to choose one. Huddle. Yes, Mr. Henderson just got 1 credit hour to his continuing education requirements as a lawyer, courtesy of the judge. His daughter whispers in near. Judge Kranick is amazing. I put him right up there with
Judge?
Judge Carroll.
I'll start this way first. One of the exceptions to the hearsay rule is business records exception. So if it's a business record and it's kept in a normal course of business, then someone can come in and lay the foundational things for the business record exceptions to the hearsay rule. However, in this case, that would not be needed if the court takes judicial notice of it. That eliminates the necessity to do a business record in that foundation, because the court, under the statute, 90.2026 can take judicial notice of court orders. This is a court order. It's certified. I think it's an exception to the hearsay rule. Also, I think the probative value of these documents outweighs any prejudicial effect.
Any other argument?
No, Your Honor.
Any other argument, State?
The fact that there was a pretrial court order of no contact between them is going to come in. I mean, on one of the body-worn cameras, Mr. Torres is like, well, the court said I couldn't, but she said I could come. And I believe she testified to that during her examination. My objection is to the paper and the grounds that I've argued.
Okay. All right. Thank you very much. State v. Mobley, 98 Southern 3rd, 124 by the Florida 5th District Court of Appeal, cited in 2012, says that there's a procedure that specifically needs to be followed for judicial notice, as set forth in 9202 and 9203. State is conceding that although there's not a writing, they're not objecting to the judicial notice concept. They're objecting to the evidentiary bases. I do find that it is relevant, but the problem is I have with hearsay. And the court, in relying on the Florida Supreme Court decision in Dufour, D-U-F-O-U-R v. State, 69 Southern 3rd, 235 at pinpoint 253 by the Florida Supreme Court in 2011, which states, while the court may take judicial notice of documents in a court file which were properly placed there, this notice would not make the contents of the documents admissible if they were subject to challenge, such as when a document is protected by privilege or constitutes hearsay. It is an out-of-court statement that is being offered for the truth, to wit, it is a no-contact order, and the requisite requirements for a business record under 98036 subsection A have not been met, nor has there been a certificate from the custodian of records as to those things, as required by section 6, paragraph C, and the timeliness of a certification. So I cannot accept judicial notice of these two documents, even though the state is not conceding the procedure for judicial notice. I am sustaining the state's objection as to hearsay under the grounds and the exceptions that you have offered.
We're going to do the goat scream because the judge is the goat. Absolutely amazing. On the fly, pulling case law, where none of the two lawyers argued case law at all.
Court subpoenaed. I don't know where they are. I assume they're somewhere in this building. I believe they...
I'll get you a goat link.
Sent some message to us back before the hurricane about what date they were to come, and we said to be continued. So we haven't gotten back up with them yet. So it would take me some time to check on that. It's 4:30.
Was the subpoena still for this time period?
Yes, I believe it was a 3-week period.
Okay.
But we haven't followed back up with them. This came up.
Sure.
Late.
I'll give you an opportunity to do that.
Wow.
I don't know whether you could just go ahead and send them to home for the evening, and let me see if we could find the clerk maybe in the morning, and then we could rest in the morning, and then the state has Dr. Werner. It's probably going to take me a little bit to find.
I'll give you that opportunity. Absolutely.
Right now?
If you want to, sure. If you want to try to do it now or do it tomorrow, I'll leave it to you. Because I can't imagine it would take long if we're able to get a records custodian or a person to lay the foundation. I can't imagine it would take that long.
Aren't they in the building?
Yes. 3rd floor? Sure.
I suggest we go ahead and let the jury go. It's 4:30.
Okay.
I don't know how long it's going to take them to do that, but we could present that in the morning and then rest in the morning, and then they can.
All right, that works for me.
I'm not going to make some poor employee come in and do that. I was conceding the authenticity. I just don't understand the relevance of it coming in.
Are you now withdrawing your hearsay objection?
Well, I still believe it's hearsay, but I think it's cured by it's a public record and it's stamped and all that stuff.
I know, but no one's made that argument yet.
I don't want to punish some poor clerk.
Okay.
Defense. You didn't say the magic words.
But it's a slippery slope for other records. We'll see what we do as well.
Okay. All right.
I've got a link
so
for the screaming
the state
goat.
is still maintaining its hearsay objection. I do find that it is relevant.
In chat.
I don't want to make a comment.
It is an Amazon.
So then what do you want to do, Mr. J?
I'm stipulating to, if the hang-up for the court and the defendant is that they believe a clerk of the court needs to come in and testify, I'm conceding that issue so that person does not have to do whatever that issue is.
Okay. All right. Fine.
So
then, based on the court on the concession by the defense,
now it's coming in.
Or I'm sorry, by the state. Excuse me. Do you have any other objections with regard to these two non-contact orders, Mr. J?
No more objections.
Okay. For the reasons previously articulated, I do find it's relevant. The state has withdrawn its hearsay objection. Do you want these as a composite or individual?
Individually.
Okay. Madam Clerk, could you pre-mark them and then we'll identify them, please?
If you'd rather not have the holiday version of the goat, I'll give you that link here right now. The standard goat is right here. There you go. That's the standard goat. I have both. I will say the holiday version is louder, but it might be because the batteries are stronger. So we've got standard and holiday. There you go. Might need to change the batteries in my goat herd. I think the jury's going to be sent home and then officially have the defense rest tomorrow morning. That will start rebuttal period for the prosecution. It may be fairly brief. I have to say those links are Amazon links. If you do click those and buy something, Amazon may reward me with a couple pennies. It won't cost you any more, but it's just a thank you they sent me.
No contact order in 2019 MM 5062, dated June 16, 2019, has been pre-marked as AB. And the no contact order in 19 MM 5114, dated June 19th, 2019, is dated as AC. Mr. Owens, you can approach. Let's just tackle a couple other housekeeping matters that we have. You can move those in when our jury returns into evidence. Are there any other witnesses, evidence, or testimony, sir, that you're going to be offering this afternoon?
I don't believe so, but we're intending on resting either this afternoon or first thing in the morning, but we want some time to talk to Sarah Boone and explain to her, why we think we should rest, not call any further witnesses, not introduce any other exhibits, just to make sure that we're all on the same page with her about what our strategy is. So we need a little bit of time. I don't know if you want to go ahead and excuse the jury for the night and then have us come back in the morning and do that colloquy with the defendant. But we do need some time with her.
Okay. All right. So then here's what we'll do. I'll bring in the jury and I'll excuse them. You can save those pieces of paper and you can move them into evidence tomorrow morning and then present. That'll work. Thank you, Madam Clerk. We'll bring the jury back at 9 a.m. tomorrow and you can continue with your evidence presentation at that time, including but not limited to calling any additional witnesses. Court can have any further colloquy with the defense at that time. The state then can put on its rebuttal case. The state, how long do you anticipate ballparking it for the court, your rebuttal case?
I don't believe Dr. Werner will take long on our part. I'm not sure how long it will take on their part. And then there's about...
How long is that for your part?
I'm not going to hold you to it, Mr. J.
Probably less than 30.
How long do you anticipate your cross being? And ballpark it. Again, I won't hold you to it.
His direct is 30. My cross is probably going to be 30.
Okay, what else do you have to present?
And then there will be about 2 hours of videos from body-worn camera and from the phone extraction. Mm-hmm. And then reading a good bit of phone text messages into the record.
Separate and apart from the 2-hour video presentation. Okay, got it. All right. Okay, so that's going to take us in tomorrow afternoon. Are we going to be in a position for the state to rest its rebuttal case tomorrow and proceed with closings, or are we going to proceed with closings Friday morning after had the opportunity to have a full Not that we would not have a full charging conference, but after having a charging conference Thursday afternoon with regard to the jury instructions.
I just don't know how long. I think all the instructions are pretty relatively simple and straightforward, except for 3.6.
Agreed. 3.6F. I agree.
That's not going to be simple or straightforward in any way.
The instruction is complicated. I agree.
And the special jury instruction on battered spouse that we're going to be requesting.
Okay.
There'll be some, there's different courts, Judge, here in Florida that have used the special instructions. There's different courts in other states that have used a different instruction. We've looked at a bunch of them, so I don't know what this court is going to be inclined to do if court would be so inclined to give a special instruction on battered spouse, and whether or not you want to consider one of the local courts, the Palm Beach County case that I mentioned before with Dr. Brennan. There was a special instruction in that case. And then we've got some from other states. I don't know what the state's position is going to be on that. So we may...
Has a draft of that been circulated yet?
Not to the court.
Okay. All right. All right. So here's what we're going to do. Okay. Let's just see how long the rebuttal case takes. And then if we have to do closings Friday morning, we'll have to do closings Friday morning. I'd rather go through and spend the time to make sure that we're all on the same page with regard to the instructions, especially due to the complicated nature of 3.6F.
That's justifiable use of deadly force.
With regard to those, the court will have Ms. Barrios email you all. She just started her drive back to Kissimmee, so it might come a little bit later this evening. I will have Ms. Barrios email to you all the red line that the court has worked on so far of the jury instructions provided by the state. The defense is to provide its markup of the 3.6F and 3.6G instructions and any other defensive instructions that the defense seeks to have read to the jury.
Before 9 o'clock in the morning?
I think so. That gives the state the opportunity during the lunch hour to review them in advance of our charging conference.
I'll have it done before 9.
Okay.
Judge?
Yes, sir.
There was one thing. The state had filed a motion requesting a special instruction as to, I think it goes to voluntariness. I read their motion and the proposed instruction. I have no objection to it.
Okay. All right. So just so the record's clear, we're referring to the state's request for special jury instruction regarding Florida Criminal Standard Jury Instruction 3.9B, defendant's statements filed October 22, 2024. The provision that the state seeks to add to the 3.9B instruction reads as follows. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. The state state, have I read that correctly?
I believe so, without reading it myself.
And defense, you have no objection?
No objection, Judge. And it's my understanding there's already the standard instruction. That's an add-on to the standard.
It's just a matter of where y'all want it. So I will add this to the red line to be sent out this afternoon. Ms. Boone, I want to have a couple other conversations with you, ma'am. Again, I don't want to know specifics of anything that you or your attorneys have discussed, just whether or not you've had those discussions. Did you hear the court read the proposed additional language to the jury instruction about your statements?
Just now?
Yes, ma'am.
Could you please read it one more time?
I can. So just to give you some background, ma'am, there's a form instruction. It's 3.9B, and it talks about how the jury is to consider your statements that were read to them and provided in evidence through the course of the trial. And that they're to consider the voluntariness of those statements and whether they were coerced. The state is seeking to add the following language to that instruction. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. Do you understand that portion of the instruction?
Yes.
Do you have any questions about it?
No.
Okay. Have you had conversations with your attorneys about the proposed additional language that I just read to you?
Not yet.
Okay. Let's go ahead and have those conversations tonight when you all break and we can go over this tomorrow when we have the charging conference. But I'll go ahead and add it to the red line for the purposes of our discussion tomorrow.
Thank you, Judge.
Okay. Anything else, State, we need to address?
Thank you, Your Honor.
Defense, anything else?
No, sir.
Okay, let's go ahead and bring our panel back in, and we'll tell them we'll commence tomorrow with additional evidence and testimony at 9 a.m.
Caught 80s music man sneaking through the gallery. Welcome, my friend. We're rapidly approaching the end. Rebuttal. Rest is going to happen. It sounds like the defense is going to rest tomorrow morning, first thing, after first admitting those two no contact orders from those prior cases against George, where he was not allowed to contact Sarah. That's my understanding. So those are coming in, and then the defense will rest. It then switches over to prosecution, who has a half-hour-long witness. They have a couple hours of video, text messages, and things like that. So it'll take us pretty much through past lunchtime, and then they're going to be done with their rebuttal case. We might then break for the day, send the jury home, have a charging conference where we'll go over the documents, where specifically that 36F, which is Florida's rule about justifiable use of deadly force, is going to be fought over. And this one is crazy. There's a lot to it, and there's going to be a lot of fighting, getting the wording right. And then we'll have closings probably Friday morning, and goes to the jury before lunch. That's my call.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
I do.
Thank you. Y'all can be seated. Members of the jury, good late afternoon, early evening, I think. Again, could you just raise those hands, confirm that you complied with the court's instructions? All right, record reflect all hands have been raised. Members of the jury, it's 4:43. We're going to go ahead and break for the evening. I'm going to ask you to be back here at 9 a.m. tomorrow morning. We'll continue with evidence and testimony presentation by the defense, and then we'll proceed accordingly thereafter. I want to read you the same instruction that I've read you multiple times over the last week, and I beg your forgiveness as you hear it again, but I just have to keep reminding you. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors, do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, again, I thank you for your time, your sacrifice, and your attentiveness in this matter, and we'll see you tomorrow morning at 9 a.m.
We basically made it through this trial without a mistrial, which is great, because I think this should only happen once. But what is not sure is the outcome. As Miss Boone sits right now, she is innocent unless proven guilty, and the jury has not made that decision yet.
Y'all can be seated. Thank you. Anything else we need to discuss, State, before we go into recess for the evening? Defense, anything else?
No, sir.
All right, we'll see y'all tomorrow morning at 9 a.m. Thank you very much. Court's off the record.
All right, the judge and the law students can go back and chat up what happened today. Judge can own oops, that was my oopsie on playing audio in court as he replayed someone's live stream, possibly Court TV's, possibly ours, possibly Law and Crime, possibly Fox 35, Trial TV Live. There are a lot of people covering this live. some of, or at least live from the courtroom. A lot of people more covering our feeds from that. Are you retiring after this trial? No. What I am going to do is I'm going to reach out to our contact that Jules made. That would be Susan Constantine, and see if we can line up something. She was in court today. She's a body language expert. She was watching very closely members of the jury, specific members of the jury. And I'd love to see if we can connect with her and get the, her observations on this. We might also be lining up something with Dr. G and see what his schedule is as well. Normally, he used to have Fridays off. Friday was his down day, so we might be able to do something on Friday if this goes to verdict watch right away. Let's see. One clerk has a snazzy gold tie. Beautiful. Sarah Boone's about to be transported back to the jail. She seems pretty happy. So far, every time the judge has questioned Sarah on her level of, I wouldn't say appreciation, but how much she is on board with what the prosecution, or excuse me, her defense team is doing. She's said they're amazing. It's great. It's wonderful. We're on the same page. Yes, I understand. I'm happy with them. Absolutely. And that has not deviated at all. I wonder if it will change at all if she's convicted. Would a conviction change her belief on what her defense team did? The judge gave them an extra little break tonight so that they could talk to each other about the options, about calling other witnesses, and make sure she's on the same page. The judge has been very sympathetic to that, to make sure that she knows that she can make some decisions. Although they sort of make decisions about how the defense proceeds, she's also an integral part of that. And so allowed for time. That's why they did not rest tonight. So they'll do that overnight. Mrs. R.A., are you back? Welcome.
Can I just say how patient Scott is and you guys are for just letting me jump on mic? Thank you so much.
It's because I love you.
I appreciate that. Also, I brought you one of these.
Oh, thank you, candy.
Okay, so I have a question. We really thought that Sarah Boone was going to come at this without a lawyer due to her own life choices. She didn't.
Pro se, Sarah Boone, this would have been a totally different case.
Yeah.
Like night and day difference. I can tell you 99% sure there was no way she would ever get to that self-defense level if she was pro se.
Yeah.
She would have lost that battle.
Yeah, I think she knew enough to know that that was the battle she should be fighting, but very hard to win. Surprising they won it. So, I already know. I'm just going to ask, though, on air. Has it changed your view of the case now that we're actually hearing the whole thing? We're hearing all of the details. We're watching all the videos, everything. Have you learned things that have changed your mind in any way because she has a lawyer? Probably, because we heard everything she was going to say without a lawyer.
Yes, we didn't see the details. I wasn't aware of the details of the abuse that had gone on before. I knew it existed, but that opens up. It's a conundrum for me. It's a difficult thing. I have never been in that position, nor can I just put myself in her shoes and say, this is what I would do if I was in that position. Clearly, there was abuse. I believe clearly it happened on both fronts. I've looked at that, and I have to say that is real. I can't. I realize there's some pictures and I don't know. Was that makeup on the eye? Was that? I'm not there. I'm not looking at that. To me, I think I can say yes, abuse occurred, and at times she was a victim.
But can you hear how you're saying that though? That it's still putting her as the bad guy. It's like, oh yeah, she got the tar beat out of her and stabbed and stuff. But
that's because of her own testimony.
That she killed him. Yeah,
she killed him with malice. That's what I got from her testimony. That she said, I did this intentionally to teach him a lesson. I wanted him to make him feel. I wanted him to understand.
This is my question.
That's revenge.
Is it? Or is it just somebody who's been stabbed and beaten and tortured, snapping? Come on, we got to have the
Okay.
conversation.
This is a tough one because I think the conversation would go differently in different states. And we have
But
to,
I'm not
we have
asking
to
about
look
their
at the
state.
Well, that's what we're looking at for court as far as guilt goes. The law is written in such a way that there has to be an imminent threat, an overt act
Do you
that
believe
drives
that? I'm not asking about the law.
No. No, I don't.
Okay. So no, don't go. I'm getting him to talk. No, go ahead. Who's this?
I don't know. Let's see.
Call from Legal My Briefs.
Hey, Legal My Briefs. I pushed the 1 button a couple times.
Hi. Forgive me for still sounding really stuffed up.
Oh, you're good.
I was assuming in the beginning, maybe I'm wrong, that the defense of being a battered spouse was denied. And so I don't know, maybe my perception is a little bit warped, but I know that they were going to poo-poo a lot of the things that the defense team wanted to do. And in my head, I'm thinking if prosecution built their case on that, they wouldn't have evidence of George's abuse, like pictures of him, videos, maybe talk to some friends. You know what I mean?
Yeah, that's
Because
valid.
I think clearly they were both abusive, verbally, physically, mentally, to each other.
So then if
That's
we
how
take
I
out of
feel.
it, if we say, George, did you tell me to stop?
I've got this idea. Hold on just 1 second. Let me back up.
Okay.
Can I pause? I apologize for completely not listening and still thinking something through in my head. I'm owning up.
You
Okay,
bugger.
I am
Sure,
sorry.
sure,
I am
sure,
sorry.
Sure.
The overt act. The judge says there was an overt act. The judge said there was an
overt threat.
An iota. What was the word?
Scintilla.
A scintilla. A scintilla. A tiniest bit of something that could be viewed as that in the proper light. There have been scintillas of evidence that the jury looks at, and then it goes to the jury, and they're like, "Nope." That does not mean the overt act occurred. It's just there was enough there that it should go to the jury for the jury to decide if it was or not. I don't think.
And there's enough there that you can now present your arguments based on that premise.
Yeah, and that was. I agree. I think he did the right thing there, but I don't think the jury's going to agree with him if they were the ones to make the decision. If
And
this
you
should
know
come
what?
in, that was an overt
If
act.
they don't, that's also okay, because nobody really knows if she intended on him dying. I think she was so intoxicated. Listen, she pretended she sat down to videotape. In her testimony, she said that she knew she was videotaping him, blah, blah, blah. But in all other evidence, there was no evidence of her or herself even saying that she knew she videotaped
She didn't
him.
even remember
So-
doing it.
No, I think she didn't
Right.
know.
And then she changed her mind on the stand, though, and said she did sit down, blah, blah, blah. But anyway, so if she did go upstairs thinking he would still be asleep in the suitcase in the morning, that's an entirely different thing. I think she's probably so screwed up that might have been the fact.
The problem is you can't argue that
interesting.
because you also have that reasonable person belief. And she was told
Exactly.
by George on video,
I can't breathe.
Sarah, please, I
Yeah.
can't breathe. Sarah.
Do you know what really crucifies her is the baseball bat. The picture, that testimony made my stomach sick. And the way she referred to his little fingers, and he was tiny. His little fingers were sticking out of this broken suitcase, and she was beating them until he pulled them back inside. Like, that's really bad. That's bad.
She treated him like a child
Oh, that is not how you treat children.
in structuring his day.
No, but I
in
think she got
what he
off
could
on
do,
that.
who
Like,
he
she
could
let him
talk to.
around. Yeah.
She was
Yes.
she was in control of his life.
Yeah. Yeah. You're going to call your children now. You're going to send a Christmas gift. You're going to come inside and we're going to do crafts. That's how I think she was very controlling.
Yeah.
At
and
the
I
same
think,
time, too.
Go ahead.
Well,
Go ahead.
Wait.
I
The
think
things
that's-
she had him do were children activities.
Hey, I
the
do
same,
arts and crafts.
The same activities she did with her son, the same puzzles, the same games that she played with her son. That's it blew my mind. Okay, go ahead, Miss Sarah.
Do you remember my cartoon? Do you remember my cartoon? Oh, my God.
I have
It was it was so funny. It was the Sarah Boone starter pack, and it was him on the floor with scissors and a puzzle and crayons. But anyways, that's my take on it. And I wasn't sure if I had missed something because this COVID is kicking my ass.
I'm so sorry.
Yeah,
I wish
brutal.
Steven's Gourmet Hot Cocoa would fix it because I would get COVID every day of the week if I got to have that
You
regularly.
can't taste when you have COVID, though. It's so sad.
You know what? I looked up the spices today that you were talking about, and they're not sold in Canada.
Oh, no.
No.
So good.
That made the meal.
Yeah.
What was the recipe? Everyone was asking for the recipe for the dish. The
I don't
Italian.
Yeah, what did you make your Alfredo sauce with?
So it's just cream and Parmesan cheese. That's it.
Okay.
Like
and then
pure
you
cream,
added
not
the
like
flake.
milk, like cream. It was
Yeah,
good.
half and half is what it was.
It looked good. It looked
Oh my
really
gosh, it was
good.
the best pasta I've ever tasted. I was like, oh my gosh, did I make this? This is so good.
It was yummy.
Well, I'm going to start walking. North Carolina or something.
Yeah. We'll even let you drive.
Yeah, that'll clear my sinuses right up. But anyway, anyway, I'll let you go. Love you both.
Lego, thank you very much. Appreciate it.
Okay, bye now.
Bye.
We've got another call. Are you ready for another one?
Yeah. I can't maintain a thought process like this. I just can't hold on to it.
Hello, Sarah. This is RA. How are you doing?
Hey, Scott. Good, how are you?
Doing great.
So I have a thought, and I put it in the comments a few times. It always bothered me that they were cleaning all day, right?
Yeah, for
They
about
were
2 or 3
sweeping,
hours.
They were mopping.
Mm-hmm.
Right, they swept and they mopped. How was the baseball bat just leaned up against the table?
And the suitcase
To me-
left downstairs.
Right. Right, I think she probably went and got the bat in that time that any kind of...
You say that, but I just cleaned the house today, and it just doesn't look like it. But I hear what you're saying.
I'm not going to show you my
Right.
office. From this view,
Well, I mean,
it looks
if I
great.
swept and mop,
As long as you don't look at the floor.
right.
Yeah. You have to move stuff to sweep and mop. You're right.
Yeah, there's
So
a lot.
that to me always made me question.
If we're seeing body camera footage or something inside the apartment, that'll be interesting to see just how dirty it was. I mean, we know there was a Pepsi or something on the counter next to her phone.
Yeah.
But that might have been from that morning.
Okay.
That would mean she got up in the morning, found George, was like, gonna crack me a cold one real quick. Grab me a Pepsi out of the fridge.
Well, she did ask for
I
Dr. Pepper.
And walk outside and have a cigarette.
Yeah. Dr. Pepper, walk outside, have a cigarette, call Brian, like, hey, can you help me move something? need your help
Hey,
real quick.
Yeah, no, just don't bring the kid over.
Yeah, just, oh my goodness.
Yeah. Okay. I'm solidly standing on the let's remember Sarah's side of it thing though, because I feel like nobody is, and just straight up, she's going to be found guilty. That is the end for me. There's no way they find her not guilty.
I don't know.
I have never felt
I don't know because
less sure about
I'm
that.
with
really
right. I'm with Scott on the fact that juror number 13, when she spoke about her case, she said, I'm going to testify for my husband, which means she's going against the state. Why did the state keep her as a juror? It makes no sense.
Oh, I don't know. You need to respond to that, Scott. I wasn't there for that part.
Deanne says, RA keeps talking over Mrs. RA. Let her talk. And I was going to let you.
Oh, that was not the moment. I had nothing to say there.
Okay. I missed the question. One more time.
Okay, so I think juror number 13 is going to throw the wrench in it because when she was talking about that, when they were selecting, she said, yes, I'm going to testify for my husband. So in other words, she's going to go against the state on the charges. So why would the state keep her?
Okay, let me
as a juror?
clarify.
I heard that differently. I heard that she was currently involved in a domestic suit, where she was the victim and she will be testifying.
Right.
But I
Correct.
didn't hear that she
That's
was
right.
testifying for
That's
the
what I
husband. I thought
heard.
it was against.
I heard it differently, but I could be wrong.
Either way, you'd think one or the other side would not want her there.
Yeah, but neither side
Right.
objected. Wow. 6 people are
Anyways,
going to
that was
decide
my
this.
little
so,
thing.
yeah.
The bat, the whole situation with the bat just kept triggering in my brain. But I'm going to get back to work. Love y'all.
Thank you, Sarah.
see ya.
Thanks for the call. Bye.
Okay, before the next call, let me get this thought in.
Amber's called like 7 times, so talk fast.
Okay, if when she's describing the day and she's like, oh man, I'm not the guys. That was the fastest. That's the speed I speak at. I can't go faster.
Go ahead. You keep talking. I'm not going to address Amber until you're done. She sat on hold before. She can do it
That's
again.
great, Amber. We're so glad you're here. Okay, so if she treats him like a child or like, somebody who needs to be entertained at all points, it is either that she is controlling and she's managing everything, and this is an indication that she has narcissistic behavior and she really thinks she's the cat's meow and everything depends on her, or it indicates that she is in fact terrified of him and is placating him and don't interrupt, and is saying that I need to do everything I can to keep the situation mellow. Now, I will argue against that on my own. No, I won't. I'll let you. Go ahead.
Amber, do you want to address that one?
I'm going to pull a chat mom card real quick,
Okay.
and I want everybody to understand this. This is not the place to condemn people for their opinions, especially when it comes to Boss Man and Mrs. R.A.
Yeah, don't disagree with me or Scott when we're
Some
disagreeing with each other.
No. You can disagree, but you can disagree respectfully.
We do ask you to be respectful, and I am wrong often, and I will admit that. Oftentimes I have my mind changed by someone who is wiser and smarter and has thought it through better than I have. And oftentimes I get that in a phone call or by just talking to Mrs. R.A. But
we need to remember that we are all friends here first. We can agree to disagree. There are several that have been timed out for 24 hours for such rude comments.
Okay.
Toward
we can do
both
better,
opinions.
guys. We can do better.
Yeah, we are better than that. You guys, we got this.
Thank you, Amber. Let me answer Mrs. Ari's question. I'll let you hang up, Amber,
Yep,
because it sounds like
thanks,
you're busy.
Amber.
Okay, bye-bye.
I'm hanging up, y'all.
Bye.
I didn't see what Amber was talking about, so I don't feel offended.
I didn't either.
I'm just going to keep going like everybody loves me.
What was your comment?
My comment is that the way that she treated George that morning, the way that she was micromanaging everything, either shows that she has narcissistic tendencies
Or that she was afraid of him.
or that
right?
she was trying to manage a volatile situation in the way that she knows works.
Okay, so if she was managing volatile, why did she have the keys to the car? Why did she have the only access to the phone? Why did she control who he could talk to and when? Why did she tell him? She was in control in so many other areas that doesn't jive with her being the victim.
Yeah, and I was talking with Scott earlier.
Call from Babs.
Hey, Babs, hang on one second.
Babs, hang on one sec.
I was talking to Scott earlier and just saying the thing that is hardest for me is that she says she's explaining the situation using words that disagree with what she's saying. So the formation of her sentences comes from a position of power. It was my decision. I decided to do this. I decided to go get this takeout. I decided to do that. That is a position of power. And she is saying at the same time to try to control the situation, to try to, because I'm scared. I'm like, well, my personal life experience says those who are scared formulate their sentences in passive tones. They do not use sentences that put themselves in a powerful situation. So that's hard for me to see that conflict in the way that she is speaking and the ideas that she's trying to communicate through her sentences.
And how in the world did Julie Harper not see that as a licensed psychologist who sat with her for nine different visits?
Are you saying I got a job opportunity here?
I'm just saying
Nope.
we've got someone who it's their job to analyze this. We can see it. We can see that something's not congruent. It's not matching up. The behavior and what she's saying is just like it's black and white.
But is it black and white? That's the kicker, is that so many things show up in one way. Like narcissists are like super, I'm the biggest, I'm the best, I'm the loudest, I'm the greatest. Why? Because they feel so small and so unseen and so tiny. And so it is recognizing that somebody's behavior, did I just make them hang up?
No.
Okay. It's recognizing that somebody's behavior tells us more than necessarily what they're saying, or the way that they're speaking tells us a little bit more about how they're thinking. I don't know.
All right, Babs, you're up. What's on your mind?
You guys are my favorite, cutest couple. And because
I think we've outgrown cute.
I need a camera for you so you can join me.
You'll be 80 and cute.
You get cute again when you're 80.
As that kind of a couple, you don't understand that some couples have a relationship that's built on angst and fighting. And I think this couple was that way. And they poked at each other back and forth, back and forth. They riled up each other. He didn't know not to hit. Like Brian said, I never hit. George hit. And so he got in trouble. But she provoked him. And I think in the last hit situation, she provoked him. He ended up in the suitcase, and she did it one time too many and took him out. Yeah. So I think it was a continuation of what their relationship was all about. It was always about fighting.
Yeah,
and
I agree.
I think she, unfortunately, went way too far. And she is narcissistic.
Yeah. As I was watching this, that is interesting. Scott and I were discussing this last night. My experience with domestic abuse, there's usually an abused and an abuser. And in this situation, they're both. Yeah. And that I'm just not familiar with how that dynamic works. So, yeah, I don't know.
Yeah. Babs, thank you for the call. I appreciate it. Let me take a little break and we'll dial back a little because we are wrapping up for the day. Thank you. Thank you very much for the call. It's great talking to you. I appreciate that.
You know how much I love you guys.
Thanks, Babs.
Thanks. Bye-bye. All right. Phone's turned off for now. Donna says, we need to explain your name. Someone is asking if we're all addicts. I don't know about all of us, but I am. I chose my name sort of as a play on words. I built this YouTube channel when I thought that everyone in the world would just love to watch me go metal detecting. And I was wrong. Very, very few people wanted to watch that. But I named it Recovery Addict because I was addicted to recovering artifacts from the ground. I also have my own personal story of addiction that was a little bit different than the others because it was a computer gaming addiction. And I just about lost everything, including my lovely wife and job and all that. So we call ourselves Recovery Addict, not to mock addicts in any way. We support all those who are finding their path to sobriety, whatever the addiction is, and however long their sobriety is. We do celebrate. So you'll see, like today, we celebrated someone who's going to hit 15 years today.
And frankly, we support the supporters.
Yeah.
The people who are not dealing with an addiction for themselves, but are dealing with a loved one who has an addiction. Yep. That's big too.
So we do have that connection. I realized it was probably not the best name to choose for a true crime channel.
And truly, we considered changing it right when this started, and it was like, oh my gosh, this might turn into something. We had a discussion. It was like, do we change our name? Because if we're going to, this is the moment. And in the end, it was like, it's what people are searching for.
I could have been Mountain Dew Addict, which would have been true.
Maybe is accurate.
We do have many members of this community who maybe found us on accident and have their own stories of addiction or recovery that we celebrate. And we have just respect for the process and just some understanding here. Mostly we have just a community that's friends. That we don't always agree. I don't always agree with Mrs. R.A. Sometimes I'm wrong. Sometimes we're both right.
I kind of like it when we don't agree, though, because I feel like, hey, look. Yes, Scott, that was very funny. You had the I'm so proud of myself face. But no, I think I learn more when you aren't agreeing with me. And right now, we're not agreeing with each other. And I really just respect that. I think I respect that you've put a lot of thought into this. And you're holding your ground because of not emotion, but thought. I
have the benefit of having a couple thousand people share their thoughts with me all day long. Yes. As you can see on the screen as it's scrolling. I watch the chat more than I watch what's happening on the screen. And many people just suggest something that just makes me think.
Yeah.
Or, couch an opinion a little bit differently. I'm like, yeah, I hadn't thought of that. I'm smarter because of this community, and this community is absolutely amazing. Thank you very much, and thank you to our amazing mods. We're gonna try to wrap things up here tonight.
He looks like he's gonna grab the mic from me, guys. Is he twitching his hands?
You can stay the whole time. It's fine. We are planning on going back to the Georgia v. Ferris trial. If you have not heard this, the trial we were mentioned in, like me. I might have cracked the case live on the air.
Which is amazing.
It was unintentional. I was just saying what everyone else was thinking. The only difference was when I said it, the woman who knew that the gun I was talking about was missing was watching our stream.
Yeah.
And because of that, she called in and said, I have to tell you, I'm missing my 38 special, and there's a missing gun. We're trying to put the pieces together. It might be the nail in the coffin for the defendant. But we're going to go back to that case. We will catch up when this one ends, and we'll speed trial until we get caught up, and then watch the end of that one as well. So Melody Ferris is coming up next.
And can I just say, you guys get to see into Scott's life a lot, but you didn't get to see the moment when he got that news and he came running in, sliding on our hardwood floors on his socks. Just he slid into the room.
It was like a Frasier entrance. Boom!
He was like, guess what just happened? And I thought, oh my gosh, are the police coming? But no, it was good news. It was awesome.
Yeah, it was awesome. We'll be joining that soon. If you want to go watch that, we did the video 2 nights ago.
You're doing Melody first tonight, or you're doing it?
We're after this one's over. We did a video. You can go back on the live stream. It's a couple back. It's Melody Ferris. It's a quick one. Anyway, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again, which will be tomorrow morning with Sarah Boone, and it's going to be rebuttal and closings. Here we go. You guys have a good night. We'll see you. Thanks, Mrs. Ari.
Thanks for letting me come.
We'll see you.
I was kicked back, taking it easy.
Because he's the guy.